madam. You are the accused. 1 lakh.
कर दो ना
किसी इंस्ट्रक्शन है ना ऐसे
Till after 2 weeks we'll see. Yes.
My lord, I beg your lordship's pardon, my lord.
Page 2, item 5 to 8.
Item 5, my lord, on behalf of HS Mishra, my lord. Kindly taken up one chapter, my lord. Item number 5.
Matter.
Item number 5, my lord.
5, 2007 matter.
Next week, my lord. He's out of session, my lord.
My lord, I beg your lordship's pardon, my lord.
9 to 15.
Item number 10 on behalf of Jugal Kisar
Item?
10.
Yes.
He's in a death reference hearing today, so
Weekly report. Okay. Yes.
My lord, I beg your lordship's pardon. My lord, item number 64. I pray for an adjournment.
Wait,
I have some
please wait. We are reaching there.
Yes, yes.
Page 3, item 9 to 15.
Item 24.
Page 4, item 16 to 22. 15, Mr. Pradhan, you.
Item 24.
20. Page 5, item 18. 24, yes.
This is the matter of the year 2008.
24.
24.
2008 matter.
Yes, challenging the order of cognizance.
Cognizance.
Yes, what happened since 2008 till today, I will take up an initiative. Let this matter follow
Next week. Next week.
Pardon, my lord. Item 18. Item 18, my lord.
Item?
18.
Yes.
Pray for next week, my lord. 2012 matter. First time.
Next week of the next.
Item number 20.
Yes, ma'am.
Against the discharge petition I have come up. In the meantime, trial is over.
Trial is over.
Last occasion, your lordship had directed me to take instruction.
Yes, yes.
I contacted the client. He says trial is over and he has been convicted.
This is against which order?
My lord, against refusing to discharge.
This petition is arising of an order dated 3/3/2006, whereby the court below had refused, court below rejected the application of the petitioner in seeking discharge. Meanwhile, charge was already been claimed and the trial had already been concluded. Therefore, this matter became infectious because his petition is disposed of.
Last occasion, my lord had directed me
Yes.
to take instruction.
Thank you. Thank you very much. Yes.
My lord, item number 25. ma'am. Item 25.
Yes.
It's from Jugal Panda.
Same.
1 week.
Same.
Same.
It will be there in the weekly.
Okay.
Yes.
My lord.
May I please your lordship, fresh admission matter, my lord.
Sorry.
Fresh admission matter.
Wait. 1 minute. 1 minute. Wait. Yes.
My lord, my lord, item 31, may for 1 week after.
31. 2014. Yes.
We take the instruction, my lord.
And you seek in such 1 week of
Item 29, madam.
29. Yes.
After 2 weeks.
This is 2014 matter. 2 weeks ago. Yes. Page 6, item 35 to 46.
Item 35, madam.
Yes.
2 weeks time.
Huh?
2 weeks time.
This is 2014 matter. 2 weeks. Okay.
40.
See, 10 years. 2014. Now
Nice.
we are in 2024. Someday you have to argue.
My lords.
Yes. Next.
46.
46.
This matter may come witness.
40? Yes. What do you want?
Witness.
2011 matter.
That matter, my lord, 47 we have.
What 47A? Section 4 benefit I'll extend and finish it up. Why unnecessary? Let it be there. You argued it. Yes. Page 7, item 47 to 62.
53, your lordships.
53. Yes.
I pray for 2 weeks, your lordships, because
2011 matter, madam.
your lordships. I pray 2 weeks, your lordships.
2 weeks.
Yes.
2 weeks. Last chance.
3.
No further
My
adjournment.
lord, item number 48. Also,
Do you have any interim stay?
Yes, your lordships.
2011 you have been enjoying.
Conviction.
Conviction. Yes.
my lord, item number 48. 48. Jugal also.
48.
Jugal Panda. Item.
Mr. Jugal Panda.
Let's say item 62.
How many days this death reference will take?
Today only one day.
Yes. Next week. Yes.
Let's see, item 62 kindly taken over after next week.
62?
62 kindly taken over after next week.
After?
After next week or next week?
Next week.
Next week. Yes.
After vacation, put yes.
Yes.
Item 63.
My lords, item 68 kindly 1 week after.
68.
We take the
Yes,
instruction
2012.
on behalf of SK Divedi.
Yes.
My lord, item number 64.
Yes.
I pray for an adjournment, my lord, 1 week after. That's
This
personal.
is 2012 matter, sir.
Yes, my lord, I understand, my lord. I have some personal debate. 1 week after.
It's all right. All right.
I will do it. I will do it, my lord.
I got it listed because I know that the old matters, the lawyer's office.
Yes, yes, my lord. I will do. I will do it. I never seek for adjournment.
You can be ready at least.
Yes, yes, I will do it. But give me some time. 1 week after. Yes. Obliged.
At the request of Mr. Acharya. Yes.
Item 79 to 90.
Item 86, my lord.
86.
6.
Okay. Yes.
My lord, item number 84 on behalf of HS Mishra, my lord, kindly taken up.
86, what happened?
84, my lord.
86, what do you want?
Pray for next week, my lord.
I didn't ask anything.
Yes, my lord. Next.
Next week, 2015 matter. Okay. Next week. Yes.
Item number 84, my lord, on behalf of Mr. HS Mishra, kindly taken up 1 week after.
80?
84.
84. 2014 matter. Next week.
Obliged.
Yes.
Page 10, item 91 to 100.
See, matters from 1992 is pending.
This for the entire week, my lords.
No, but I know, but if somebody is asking, at least we will proceed the oldest matter first. 92 matters. 93, 94. See this. Why have you listed these matters at the end? It should have been at the top.
Hearing matters, my lords.
But it is at the, down the line, then it will never come. 2 p.m. But try and get the old matters first and
Page 11, item 101 to 110. Page 12, item 111 to 120. Page 12, item 121 to 129.
And that's item number 127.
yes.
Pray for 1 week after to obtain instruction about that. Learned State Council in
100,
27, my lords.
127. Which year?
2001, my lords.
Yes. Next page.
Page 14.
From 1990 to 2000. All these matters you give priority. PM, then again 1, 2, 3, it will go like that. No? By the time we will reach 87, it will be some years. Right, tomorrow you adjust the 30 minutes, but the from 1992 to 2000 matters. Come at the top. Adjust the
Division.
so that the old matters will get priority. Tell the vigilance here. As something created in the so that old matters will be more attention. All the matters from 1, 2, 3. Let us see today how it is. Yes.
Page 14, item 130 to 137.
134, my lord. 130? Pray for 1 week after, my lord.
134.
2003 matter, my lord.
Next week.
Page 15, item 138 to 145. Page 16, item 146 to 151.
Item 151,
Yes.
in sub-item 3, I am appearing. I'll file my memo of appearance in course of the day.
Yes.
The pensioner, my lords, 85 years age, who has been deprived of pension. Let it be taken up subject to convenience of my other
Yes, yes.
learned friends.
I'll take it up. You get ready. If you are ready, the other side is ready. If any matter,
There are connected
both the
matters.
sides are ready. I am ready to take up any time.
Oh, there are
10:30 also. I'll
matters
take it.
also, so that's why.
I'll take it up. You get ready. Yes.
Thursday or Friday, someday your lordship may fix it so that you can.
You tell who is in the connected matter.
Connected, there are two other
Mr.
matters.
Mund is there.
Mr.
you-
Mund
you
is
ask
there
him.
and Mr. Dhara is there.
You ask him and mention so that I'll fix a date. I have no issue. It is there on the list. It will remain in the list.
That's any other day, next week, any other day.
You give a fixed date so that I can take it up.
Next week,
Because it's
then,
there in the list, no problem.
we can do it on 3rd.
Because it is in the weekly list, if you people agree, I'll take it first item. How does it make difference?
We can do it on the 3rd of July.
3rd July.
July, other matter is fixed. 3rd July, other matter is fixed, your lordship.
What do you want to tell me?
Fourth.
Write down 4th July. Huh? The 4th July indicate for the top
4th July at top of the
top
board.
of the board. At 2
Lords,
o'clock.
First
2
week
o'clock.
of July, your lordship has already fixed two matters, my lords.
4th July, brother.
4th
No,
July.
first week of July, there are already prefixed matters. Two matters, your lordship.
Well,
has already
ଏଇଟା
fixed.
ଗୋଟେ fix ହବ।
You are so capable person.
ତମର କଣ ଧରିଛି?
You get ready. Let them argue.
My lords.
If you need, I can accommodate you.
Great.
4th, but get ready.
Yes, ma'am.
Try to get ready. Okay. 4th, sir.
Obliged.
Yes.
Page 17, item 152 to 157. Page 18, item 158 to 162.
160. 14, 2014. Get ready because I expect that seniors should get ready so that we can.
Pardon me, my lord. Item number 8 at page 2.
Huh?
My lord, 1 week after I am trying to contact the appellant. It was my whole problem. is 8.
1 minute.
Serial number 8, my lord.
8, okay.
So it has come under the headings of orders.
Yes.
I'm trying to contact
Is
the.
it conviction matter?
Yes, my lord. Vigilance.
1 week.
Yes, my lord. May I pardon, my lord? Item 15.
Request of Mr. Das. Reach the matter on trial said.
Vigilance.
And Mr. Das submits that he would obtain the latest status up to the petitioner in the present case.
May I pardon?
Yes.
Item 15, my lord.
Yes.
Kindly
15,
take note one which after
15 mark करो।
15.
my lord, 1-5.
2011 matter. Sir.
Mr. Das has some personal difficulty.
Okay, it's all right. Next.
My lord, item number 9. I am in VC.
Yes,
Item number 9, my lord.
Proceed now.
My lord, fresh admission matter, my lord. Cognizance question for cognizance question. Congal,
Wrong court mentioning.
I have not attended the court. I am in house.
Okay, 9 next week. Due to personal.
Obliged, my lord. Obliged.
Then counsel, Mr.
I hope so.
Yes. Yes, sir.
If your lordship has granted bail, subject to condition that is the subject to verify the criminal antecedent of similar nature. He has one criminal antecedent of similar.
Similar nature.
One.
What is the status in that matter?
He has already been released on bail in
In
that.
that matter.
Yes.
So what is your problem?
Since there is a condition, my lord, if he is having one criminal antecedent of
Similar matter, my lord. For that reason, my lord, though my lord is more than commercial quantity, and similar matter there, for that reason, the Lord court will have.
Commercial quantity.
37 bar, my lord. And 37 bar. And if he will not repeat similar type of, then only they.
Then only, that's the whole difficulty.
Your lord,
In this case, what is the recovery?
23.70 grams.
In the other case?
Other case, my lord, that 257 grams of brown sugar. 6 persons were there.
Here, ganja, there, brown sugar. All these things.
6 persons were there, my lord, for which, my lord, he has been granted bail. Here, my lord, 23.7 is the riding the motorcycle and person who is
That's right, but
a pillion rider who was holding the
what
bag.
have you moved? Why don't you challenge that order?
Yes, order has been challenged. Me.
Now you have, what is this application?
What is next bail application? Earlier, this was filed.
No, today why it is listed? You are asking for
bail, my lord.
My lord, after obtaining bail order from this honorable court, my lord, he moved the court below. Court below rejected it, saying that since the similar type of offences against him, for that is the court.
And now he has moved first bail application.
Yes.
Why it is listed? Because I have given.
Yes,
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 my lord.
Okay. You are in custody since?
Lord, 6/12/2023.
6/12/2023. Not even a year.
Yes, sir. Any condition. He will appear before the police
You
station.
call CD will see. Which is the brown sugar involved. That is the problem. I am very interested.
Where the public prosecutor opposes the application, the court is satisfied that there are a reasonable ground for believing that he is not guilty of such offence, or that he is not likely to commit any offence.
That's the whole difficulty. That's the
While on bail.
37 direct bar.
Aye.
But let adjourn it to get a share.
Aye.
Did call करके वकील उधर देना देखिए इस दिन रहो वर्षे भी ही अभी तेरे अपन
जी धरती लागन से गलानी
गंजा ब्राउन सुगर
any condition you will appear before the
obviously condition will be there but we'll see CD okay किस दिन रहो
Aye. 2 weeks after.
2 weeks after 2 weeks
I can see.
yes
There are two applications.
three this is
Flags.
against what
Remember, this is a leave application to continue the appeal.
Substitution
Since the
application.
yes, since the revision petitioner died, the
what
legal
is the
has-
offense
That's
draft case 13-2-13-1D.
7, 13, 1D and 13.
applications allowed
In fact, I have filed the objection also at flag E.
flag E
Yes, my lords.
delay
Yes, my lords. Objection to section 5 limitation petition.
Yes, I filed a limitation application.
when he died
My lords,
Died
date
on
of the
29/1/2012.
my lords, it's an inordinate delay of 11 years, 6 months.
appeal is this revision is pending since
Yes,
But
but
this
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 appeal is
revision-
pending since
94.
94 months.
or in between he died. Is there anything on merits?
Yes, I have a very good case. Otherwise, I would not have filed the application. If my friend will go through the judgment itself, my lord filed there is no question of demand and acceptance of right. Money was paid for the purpose of arranging a feast.
Was there any confiscation?
No, my lords.
Confiscation? There is no confiscation.
No,
Only you want an acquittal for
yes, because because
Whether-
financial benefit the legal heirs will get.
and the stigma also,
Yes.
family stigma. Examine.
Sorry, my lords.
See, during the pendency, what happens is if the during the pendency of appeal, he had died.
My lords.
Obviously, nobody keep a track of the matter.
Only on the question of the delay of inordinate delay of 11 years, 6 months. That's all. So, subject to your lordship's discretion. That's as a lordship.
Your
please.
lords may impose some cost. I will pay the bar association. It is better.
I don't think if for a lady. we should
94
impose,
appeal. My lords.
post. Rather, we should hear the matter and.
Yes.
Yes, your lords may allow this and fix the date of hearing. I will close the case.
Tomorrow. From tomorrow.
Tomorrow again, I will declare.
94, sir, 94 repeat.
Next week, Monday,
Day
Tuesday,
after,
Monday, Tuesday, any day.
think of this week.
ନାଇଁ ସେଟା ବା ଅଛି ବା ଆପଣଙ୍କର ମ୍ୟାଟର ଟା ଅଛି
Monday, side for
Monday or Tuesday any day lords may fix I'll
Monday. Huh?
Tuesday or something?
Tuesday already packed.
Okay.
Monday रखियो एटा. I'm not passing any order. I'll allow the application, both the application, and let us see the merit.
Yeah.
Prima facie, if he has a good case, I'll allow.
Right.
If he doesn't have a good case, then on the ground of limitation, I'll dismiss. Simple.
My lords have
If
fixed.
prima facie you have a
yes
good
yes
case,
yes
then I'll condone the delay, go into the merits.
correct
Yes.
correct
If you don't have a good case, then on the ground of delay, I'll dismiss.
My
So only your lordship,
Finish.
your lordship have a glance to impugn judgment itself.
Yes. We'll
I'll-
hear
I'll-
it Monday, Tuesday.
Only page 5, your lordship, entire case is page 5. Page 5 of the impugned judgment.
Yes.
Page 5 of the impugned judgment.
Yes. Read it.
Well,
Yes.
I got it, page 5.
Yes, yes, I'm there.
That third line, that he has not accepted the bribe from Sri Sahani, but Sri Sahani had forced the tented money into his table drawer, requesting him to arrange a feast with chicken despite his refusal. What more, my lord, evidence is required?
There is no acceptance according to him.
No. That is the corroborated by Pedal 3 overhearing witness.
For Monday. If I satisfy, then I'll condone the delay, I'll go into merit. Otherwise, on the ground of delay, yes, Monday. Okay. You filed the, have you filed response to the application for condonation of delay?
Yes, my lord, that is at flag E.
Yes, you have filed.
Yes,
Yes,
yes, the
already.
response is filed.
That has
flagging.
come on record.
Yes, yes.
He has to do his professional job. By yes.
Item 4.
Monday 2 p.m. If it is a case of acquittal, I'll condone. If it is not a case of acquittal, then I'll condone. Okay. Yes.
Item 4.
My lord, the miscase is infructuous. The matter is otherwise ready for hearing. Let it be listed for hearing.
It is already listed, sir.
Today,
We are not ready. So let it retain in the board. So this weekly, it will be included in weekly. Get ready.
okay. My lord.
Yes.
My lord, which item?
IA has become infructuous.
Yes.
What is that IA is about?
Suspension of
Suspension of sentence.
Already, he has already been dismissed from sir.
Okay. The application IA number, which IA is that?
543.
IA number
543.
543.
Of 2006.
It's rendered already become infectious. According to the IA disposed of, leaves the matter for hearing. Yes.
My lord, so lordship will
Please
direct.
appeal for hearing.
My lord, item 4, we haven't received the paper book yet. Your lordship will direct the registry to provide us a paper book.
Registry is directed to provide a paper book of the appeal to Mr. Rizvi. To Mr. Rizvi within a week.
Grateful.
Item 6.
5 Konala 5.
5 has been adjourned.
Item 6.
In fact, not in 6 also the paper book is ready. It can be heard and disposed of.
None appears for last occasion में कोई appear नहीं है. इसके पहले taken up by on the when the matter was taken up on 6/3/2024, none appear for the petition. Even today, none appears. In the interest of justice, the matter is adjourned to next week. We will video.
Lordship is calling this matter on matters.
I see last occasion none appear.
Nobody
Today,
appeared.
nobody appears.
Matters.
I am adjourning it. Next time we will appoint amicus curiae.
Amicus, yes. So next month, so 1 week after, 2nd of July.
Yes. Item 7.
7.
7 Amar.
7.
Amar.
7, my lord.
Yes, sir.
7, my lord, on behalf of Mr. D.K. Patra, Lord, we are appearing for appellant number 1 and 2. And an IA has been filed, my lord, for substituting legal heirs of appellant number 3. That, my lord, we have not filed.
Who is that? Who is filed this application?
Revision.
And in the meanwhile, my lord, we have instruction that appellant number 2 has also been is also dead, my lord. Appellant number 2.
Okay.
We will take instruction whether, my lord, the legal heirs want to continue.
Petitioner number 1 and 2 submits that he has got an oral instruction that appellant number 2 has already expired. You want to confirm the same. Confirm the same. adjourned for 1 week, huh? Insofar as the.
My lord, two
application-
weeks. We will also,
two
yes, my lord, take steps if the legalers wants to continue with the
Okay, 2 weeks.
appeal.
Insofar as the application moved by applicant number 3 for bringing the LRs on record of the applicant number 3 is concerned, the same application is allowed. IA number 482 allowed.
Once that IA, the copy of the IA has not been given to us.
There is no delay, nothing.
Yes.
Yes.
When is,
Yes.
okay, okay.
Please.
Item 11.
Senior counsel.
An application for grant to appeal to continue the appeal under section 394(2) of CRPC, my lord.
Yes.
The petitioner is the wife of the deceased appellant, my lord. Filed this
Is there any
application
delay
for
in moving
substitution.
application?
Delay, my lord, 5 months, 2 days, my lord, delay.
Huh?
5 months, 2 days. Due to COVID-19 and also suffering from lumbar spondylitis. And this type of case of this honorable court granted order, my lord.
Delay
This type.
delay condone allowed.
Yes, my lord.
Delay condone application. Which application is that, sir? Application number?
Limitation petition filed, my lord.
No. Which application is that?
Same type. Only next.
IA number?
1135.
Admission
1135. Application for continuing the appeal through LR for the appellant is allowed. 1136 2020 condonation of delay. Delay is condoned. Delay condoned in view of the statements made in terms of the statement made in the application.
That's my former objection may kindly be.
Rizvi vehemently opposed the application for continuation of delay. Since the delay is only 5 months, I am inclined to condone the same. Accordingly, the delay is condoned. The LRs of the appeal are taken.
Let's be directed to prepare the paper books, my lord.
Take the pen drive, no paper.
Well, its paper book is yet to be prepared. It has not yet been prepared.
Not necessary.
prepared, no.
Not necessary. You take the pen drive and the paper book business gone. We are in digital world. Take the send your junior.
My lord.
Send your junior with a pen drive and get the entire record.
Yes, yes, yes.
Entire record. Yes. When can you be ready to argue? When do you want? For main appeal? You have to argue main appeal. When do you want?
My lord, after 2 weeks, my lord.
2 weeks for appeal. 2 weeks. 3 weeks, 3rd week, 4th week. Yes. Yes.
Item 12.
Well, the appellant filed 4 sets of a paper book. That is in noting that the necessary correction of paper book may be kindly 1 week after.
What necessary correction?
Necessary correction of the paper book. Paper book
Forget-
defective is that.
Forget about the paper book. What kind of correction?
Just noting is that the
Ignore it.
That's it.
Better get ready for argument.
Yes, that's
Because
And
the entire
it-
picture is there. If any defect, we will point.
Lordship may
Yes,
accept the
yes.
paper books. That noting,
Paper will be accepted.
May-
yes, accepted and a
Take
copy
on
may be
record.
served on.
fixed date.
Copy of the paper book may be supplied to Mr. Rijvi, and counsel for the respondent. Leave the matter for final.
July 5th. July
Fifth, he period.
15th,
Second.
second week July.
Yes.
Item 13, let's see, maybe fix a date for hearing. Item
Item
13.
15,
The order-
I may be pardoned, my lord, I am appearing through BC. I am appearing through BC.
Get ready at least one matter.
Yes, sir.
I am appearing through BC, my lord. Am I audible, my lord?
Yes.
I am appearing in item 13, my lord. Myself, Sanjay Kumar Das, appearing in item
yes.
number 13.
You record the presence of Mr. Das. in that matter.
Paper book may kindly be supplied. Registry may be directed to supply the paper book.
Yes. Mr. Das, I have already directed.
And this matter may be listed in your lordship's list, cause list 2 weeks after.
Yes, 2 weeks after.
2 weeks after in the hearing list, as it has been listed today. So 2 weeks after it may be added to the list.
Right, sir. Yes.
Paper book may be supplied.
Yes. Paper book जो ready है सब supply कर दो. I need not tell all this. जहाँ paper book ready है, you just tell so that it will be supplied.
Yes, madam.
Yes.
Obliged, my lord.
Yes, sir. 14.
May I please your lordship?
Yes, sir.
The revisionist petitioner died a substantive sentence with fine, and I filed this.
Fine only. Fine. Substantive sentence.
Fine is there. So I filed the legal error. Filed the.
What is the fine?
Fine 5,000 per. 5,000. 5,000.
Only 5,000.
No. Substantive sentence is there that will be abated because only fine, so far the fine is concerned.
Fine, I'll waive fine. I'll waive the fine.
Madam?
I'll modify the fine and finish it up. Unnecessary by to unnecessary.
Okay. That will make accepted.
There is no point doing it. See, there is substantive sentence. The accused has died, so it will be abated. And insofar as the fine is concerned, I will modify that sentence. Finish. Right down.
Lordship.
Dispose
Dispose for the Becker kind.
But in this case, Lord, the 4 lines, so the facts. He utilized a particular caste certificates to get a job. Actually belongs to Gudia, and but this patient service a particular certificates of Kumbhar. And saying that on the ground in 313.
We are not going into merits at all. I am modifying the sentence.
I need to know about that, sir.
Huh?
Fine amount is
fine amount is waived. Finish. I modified the sentence. Yes. दे दो लिख दो note करो. And now you only give it. Don't give it after 2-3 days. I'll forget. Just now give it. Yes.
My appearance was recorded.
Yes, appearance record will be fine modified.
Item 16.
After 2013, it was not listed. This matter was lastly listed before this court on on 19/6/2013. Thereafter this thereafter 19 last thereafter none appears for the petitioner. In the interest of justice, on 13 for the first time listed. Yes.
Item 17.
Yes.
May I please, Your Lordship?
Yes, sir.
Mr. Kanungo is on his way. He is for the contractor. I am for the executive engineer. Your Lordship.
He is there already.
He is there. He's coming.
He's contacting his client.
This matter relates to a construction of a road under the Prime Minister Yojana.
Yes.
So that is governed by virtue of a notification and circulars issued by the central government.
Right.
here, my predecessor was for a major time. I was also for some time.
Convicted by trial court?
No, it's against discharge. Rejection of discharge. So my predecessor, unfortunately, he is no more.
Ready?
Lords, I'm ready, but it could take some time, Lords, after lunch, Lords, or tomorrow.
We'll proceed after lunch.
But that is, a
Finish up
date
your-
is there in that in the court list, Lord. Let court master verify this one. That
There is
list-
a stay operating in their favor.
one.
Not stay, adjournment. If any adjournment, is-
Anyway, but-
and that order is only
When
today
date
will
is
avail for the first
on
time.
9/7,
It's there
they
today.
collect-
Till that it was not there.
We'll proceed and finish it up.
My lord, this is a case? 17-year-old case, my lord. It is still going on.
Therefore, it's better that you finish it up unnecessary way.
Yes.
Yes.
If Lords, you can look at the cost and then the list, my Lord. It stands urgent to 10/7. I'm ready, my Lord. I've got the note of submission ready. But Lords, you can peruse it.
Yes.
Notes appended to item number 17.
What does it say?
Stands urgent to 10/7/2024.
Can the court
Why?
report it?
No, my Lord, sir, this is the notings, my Lord. I don't know, my Lords.
Where from? How these notices are coming? Matter is listed today, why it is stands urgent? Huh? Registry people.
That's why, my Lord, I'm making it tomorrow.
Every time.
My lord, every time the matter comes up, it gets.
No, sir, we will hear it. We ignore that.
Yes.
Huh?
4 cases are there.
What is allowed?
But 3-4 cases, somebody might have made a mention, or another date would have been given. That is no issue.
Where are those matters, connected matters? Connected matters are not listed.
All listed, my lords.
All listed. Anybody has mentioned it?
Most likely.
But that makes no difference.
My lord, insofar as our case is concerned, my lord, it doesn't make any difference.
CS2 urgent to 10/7. There is noting. There is a noting. That's the problem. So then on 10th we will hear if I have urgent it.
My lord,
Your lordship has not.
How it is noting has come? CS2 20th June 2024, urgent to 10/7/2024. What is this?
Well, I think my friend has filed an IA for early hearing. So that I think has been adjourned to 10/7.
Application.
An interim application
Interim
for early hearing.
Early hearing, then it is noting who has written 10th, how they got the date, huh? How the registry is writing like this? Let's see.
No order was passed ever.
No order has been
Just
passed.
see this one. Show it to them.
No. It's there in the list.
No, why? I just want to know whether this registry is trying to play smart or what. I just want to just check it up.
So far I am concerned, I think I outdated with the system
But
of the court, how it's functioning nowadays.
You will know better than anyone.
No,
else.
the
How-
system has changed, my lords. The court we have seen at the threshold is no longer exists. Neither the building nor the system.
Along with the building, the practice has also
Yes,
changed.
yes,
Just see
Lord.
what is this, I don't understand. Where from these dates have come? Last line is this. CS2 urgent to
Adjourned to 10/7, my lords. What matter?
who has given this authority to the registry to urgent a matter?
CS.
To
Yes, my lord. Unless your lordship passes a judicial order.
Ask what is the meaning. The registry start adjourning the matter, then
My lord, probably that IA he filed for early hearing.
no, it's
After-
right. It's right. Adjourn to.
Adjourn means he made a mention, a court slip might have gone indicating that list it on 10th. Court slip,
Let us understand what exactly.
Unless your lordship passes a judicial order.
Then
it
it-
cannot
there is
be
no
placed.
meaning. And that cannot be a hindrance.
Huh.
Clerk लिखला कौन?
Okay. There is a reason. There is a reason there. ये शुभेंदु शेखर महापात्रा मैटर adjourned to 10th July.
Oh, my matter.
शुभेंदु शेखर, which matter is that?
My matter.
You are
356.
Your matter is adjourned to July with the order. On 20th May 2024, there is an order. In view thereof, this matter on service.
On that day, my matter was on the top. So,
That was this is the order.
but
That is the reason.
if your lordship wants, hearing is not an issue, even if date is.
No, it's already adjourned, and I have given
All-
some
all right.
unnecessary. We will not add to confusion.
Interim order, interim order.
Interim order. Please the matter on 10th. But get ready and come. Mr. Das,
We are always ready.
Today also we are ready.
get ready and come. 10th, there is, I am making an observation that leaves the matter, all the matters on 10th. It is made clear that no further adjournment shall be given. If any, if adjournment will be prayed, that would be subject to heavy cost. Either of.
May I suggest one thing, my lord? Can it be in the noting, my lord, 2 p.m., my lord, so that everything can be
Let
sorted?
it be at the 2 p.m. I'll impose heavy cost. If they will ask adjournment, I'll impose, you will ask adjournment.
I never prayed for time.
I have
I
indicated.
never for time.
We are desperate rather.
I have indicated heavy cost will be imposed if
My
adjournment.
lords,
I've never prayed for
heading
time in
on this-
discharge rejection of
as you were
cases.
saying, my lords, this matter has been adjourned to 10, and your lordship is fixing it up on 10. May I pray, my lords, because 10th I'll not be here, my lords, to go for a darshan. Either your lordships, if your lordships with everyone's consent can prepone it, 5th or after 10th any day.
10th, 12th, 11th, 12th.
My lords, who gote hote se
Then you
Rameshwaram
take.
darshan.
Then you take.
15th, 16th, any day.
15th. 15th, huh? And this order stands. Cost will be.
Check out the check.
ଆପଣ ଚେକ୍ କରି କହିଦେବେ।
ମୁଁ କହିଦେବି।
ହଁ କହିଦେବେ।
List of documents in index, with index. For argument, already.
Easy. Which one?
Hearing
40?
41, 42.
Note କରି ରଖିଦିଅ।
Pass over tomorrow I will do it.
It will remain in the board, don't worry.
This matter was last listed on 2019, and after 5 years this matter has come. We need to take some instruction from the client.
Counsel for the petitioner seeks an adjournment on the ground that lastly the matter was listed on 2019. Therefore, she has to reconstruct her file. Accordingly, matter is adjourned for 1 week.
Lord, sir, may I pray, let them, your worship, direct them to serve us a copy of them. Say, I haven't received.
Petitioner, counsel for the petitioner is also directed to supply a copy of paper book to Mr. EGV.
Grateful.
Grateful, my lords.
Worships are calling this matter.
The directions are to be complied. Huh? Give a
Yes,
copy.
yes, my lords. I'll comply.
Your worship are calling this matter 1 week after.
He will give 2 weeks. 2 weeks.
2 weeks after.
Lot of matters.
Yes, my lords, I do understand.
Yes.
20.
This is an old matter, my lords. The impugned order pertains to 2003.
Yes.
The impugned order dated 9/4/2003, by which the charges has been framed. If lordship turn to page 13. But I think, my lords, everybody has lost interest, my lords. Last time also there was no appearance.
When the matter was taken up on 20th June 2024, the following order was passed. None APS for the petitioner today. The
Impugned order is dated 9/4/2003.
In the present petition, the petitioner has essayed the order dated 9/4/2003, passed by Lieutenant ACGM, ACGM Cuttack in Vigilance GR case number 3 of 2002.
Framing charges.
Whereby charges have been framed against the petitioner. Since there is no representation of
A small modification. Impugned order is dated 9/4/2003, but the charge has been paid on 16/4/2003 at page 13.
charged and accounts for the petition, respondent submits that the charges
Framed.
already framed on
16/4/2003.
Since there is no representation on behalf of the petitioner in the earlier occasion, also none appeared for the petitioner, hence the petition is dismissed. Yes. Next.
21.
Mention, my lord, 15th, my lord.
Give it later on.
My lord.
Why are you interjecting in between?
Item 21.
This privilege is only for seniors.
My lord, sorry, my lord.
Juniors can have the.
Pardon, my lord, pardon, my lord.
Yes, yes, you can do it. No. Yes.
No, this is also a case, my lords, the input order dated 2003
The,
to return the seized money, my lords.
all right. The matter was. I'll pass it over. After lunch, we'll see. And the last date, nobody appeared. Therefore, there is a indication of dismissing this matter. Huh?
My lords.
Interception. It take up. Okay. Pass over. Yes.
22.
So 21 is passed on.
Pass over. 2 o'clock will dismiss it. Yes, nobody comes.
22.
22. Also 2 o'clock. None appeared last occasion.
Yes, my lords.
What is
Here
this
also 1/10/2005 charge has been framed.
2 o'clock. 2 o'clock will dismiss it. Yes. Yes.
26.
26. Yes, 26. Yes. Here also the same issue.
26.
None appeared. Just see, check it up. None appeared on last date of hearing. This is regarding what? What is this matter?
I'm waiting for the petitioner counsel to appeal to provide a copy.
Court record definitely.
You are going to matter, my lord, 2 days or office, my lord.
You know,
26. What is next week? 25 is of next week. 23? This possible.
The conviction under 307. Conviction under 307. Right on. On the last date of hearing, when the matter was taken up on 11/10/2023, when the matter was taken up, none appeared for the petitioner. The revision petition is arising out of conviction recorded by the courts below. Since nobody has appeared for the petitioner, I feel it appropriate to appoint. Yes, Mr. Chinchani, can you assist us? I am appointing you as an amicus in this matter. Mr. Pratap Chinchani, learned counsel for the petitioner, is appointed as amicus curiae to assist the court. Let the registry directed to supply a copy of paper book to Mr. Chinchani as well as Mr. Rahul, who stated to have lost his file.
Yes.
Lease the matter for final disposal. Next week.
1 week after.
1 week after. Next week. Fixed date, give at 2 o'clock. Supply the copy immediately. Take the particulars and supply it. Yes.
27.
May I please, Your Lordship? I have given 5,000 to
My lord, I have already received.
Then simply I'll, what should I do?
my lord, the punishment of 3 months. Settled, matter settled.
Yes.
Your Lordship,
In view of the present matter is arising out of
both the judgments.
Yeah.
Order dated 8/4/2013.
Let us write loud. Petitioner has been convicted for offence under section 138 NIX, while the judgment dated 9/10/2009 passed by HGJM Udala in ICC case number 52 of 2008. The appeal filed by the petitioner before the appellate court has also been turned down. By the order dated 8/4/2013, 8/4/2013 in criminal appeal number 21 of 21/51 up 2013 dash 0909. At the when the matter was taken up by this court, and next paragraph, the petitioner had
10,000 deposit
the
is
order
required.
of conviction and sentence passed against him. At the when the matter was taken up by this court, the parties have agreed to settle the dispute. Accordingly, the parties have settled the dispute. And then counsel for the parties have conjointly submits that since the matter has already been settled, the impugn order may be set aside in terms of the settlement. Accordingly, the impugn order dated so and so, impugn order dated so and so is set aside.
And the opposite party is directed to take the amount of rupees 10,000 deposited before the court below that direction.
Amount of 10,000 rupees, which is deposited
before the SDGM Udala.
Before SDGM Udala, in pursuance to the
Direction of
conviction, in pursuance to the direction of this court.
On 10/5/2013.
Direction of this court by the order dated
10/5/2013
may be released in favor of
OP number 2.
OP number 2. OP number.
Namely, Srushti Jara Dena.
OP number 2, namely
Srushti Dhara Jena.
Accordingly, this petition is disposed of. Thank you very much. Thank you very much. Yes.
28.
Yes. 28. What is this matter?
395, my lord. Sentence undergo RI for 5 years and
somebody is engaged as Mr. TK Sahu has been engaged as amicus curiae.
no, my lord. Last time Mr. Bikram Chandra Ghade was appeared and your lordship was directed to produce the copy of deposition to the state also.
Pass over. See, he didn't appear, none appeared for the petitioner for twice. I appointed amicus curiae.
Then he appeared.
Thereafter he appears. Thereafter again he evaporated. How to do? Pass over.
Item 30.
Yes.
Item 30, my lord, the file is somehow misplaced. My lord, if you may direct the register to submit.
What is this case about? You are petition.
I don't.
Petitioner submits that he has lost misplaced the file and want to reconstruct the same. Accordingly, he seeks 2 weeks time. 2 weeks time is granted to the petitioner for reconstructing the file and release the matter for hearing. It takes a pen drive. You leave it here.
32.
Yes. That's 2. Who is there? The matter was lastly listed on 15/4/2014, and thereafter the matter is listed today. None appears for the petitioner. In the interest of justice, release the matter on justice. 2 weeks for it. Knowledge urgent court. Yes.
33.
33 may please, your lordship.
Yes.
So already had this matter last week.
Yes.
492, 1 year conviction.
Okay.
And that has been upheld by the Sessions Court. And the
Against the
father-in-law.
husband. You are the husband.
Father-in-law, mother-in-law, husband.
Yes.
And father-in-law is 84. Mother-in-law is 79. And husband is 54.
Yes.
Last time, lordship asked whether he was working somewhere or not, because he was probation of offender act. He was not working, your lordship. Husband was not working anywhere, and in between father-in-law is dead.
Father-in-law means
Appellant number 1.
appellant number 1, Satyanarayan.
Satyanarayan.
No. Dandapani.
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 He is dead.
So what do you want? Shall I extend the probation and finish it up?
Yes, your lordship. Then another argument, your lordship, the matter has been compromised between parties.
Where is that?
Your lordship, kindly see, appellate's court order, para 7.
Yes.
Relying upon the certified copies of order dated 17/4/2010 passed
That
by.
would be a good ground for probation.
Yes, and there is also another decision of the on that ground, your lordship, that conviction under judgment and judgment confirmed by appeal division, mutual divorce between the parties under section 13B of the Hindu Marriage Act. Informant wife undertook to withdraw all the proceedings initiated by her against the petitioner.
So thereafter, after conviction, she has done it, no problem.
No appropriate steps taken by her. Petitioner acquittal of all charges. Here, lordship, kindly see the compromise petition.
It was filed.
It was filed in the lower court. I am talking from the LCA.
Right. Yes.
Para 4, your lordship.
Yes.
So you लिखते जो compromise petition टा देते joint affidavit.
Para 4.
Joint affidavit है.
Respondent Kalyani Das.
Kalyani Das will not insist upon the proceeding of EP number so and so in the Court of Civil Justice Senior Division, Pulbani, as well as the criminal appeal number pending before the Honorable Court. The above case may be closed against the appellant and his family members.
This is in a joint application.
Joint application.
This was what happened to this?
It was filed. Divorce was allowed. What is my instruction was there?
Divorce was allowed.
Divorce was allowed. The lots of kindly the sessions court order, district judge court order first one.
Yes.
The received advance today, petitioner advance गोटे लक्ष टंका देइथिले ते अनुसार बैंक ड्राफ्ट भी देइथिला. The appellant files bank draft of 1 lakh in favor of the respondent.
Where reading?
It is district court order tag.
अच्छा 18.
Okay. What are these?
Yes.
The
reason signed by the compromise appeal was shown so on last they filed in favor of the respondent along with the compromise petition. The contents of the compromise petition is read over to explain also. And the compromise petition is accepted on the part of the decree of the appeal. Accordingly, the appeal is disposed of in favor of the compromise. This is in RFA, na?
RFA.
This is in RFA.
RFA.
But this is in RFA. Okay. Regular first teaching. And this was dated 17/4/2013. When the conviction by the appellate court? Additional sessions.
সেটা দিয়া হইতলা সে কিন্তু কইলে যে ଆମ this court don't have the power to compromise. Para 7 se লিখিছন্তি.
7?
Para 7 of the appellate court order. Relying upon the certified copies of the order dated 17/4/2009 passed in RFA number.
Yes, sir. What do you say? They are entitled for acquittal. I will acquit them. Give that judgment.
Right.
Give a photocopy of that judgment.
Yes,
and this, give it to me. Para 7 of write down note में लिख दिया para 7 of the appellate court order. Para 7 of the appellate court. Give a copy of that judgment. Yes. Next.
34.
My lord, on behalf of Mr. Viraja Prasanna Das, actually Mr. Das on his legs. Kindly grant on Passover.
Passover you want? Okay.
My lord.
Yes.
After lunch, my lord.
Next.
36.
36. Anybody?
36, one pass. Just one. One Passover.
Passover. You are ready? Okay. Passover.
One pass.
Yes. And he is there. 36. No, is there. Yes, sir.
My lord.
What is this?
Case ballot where conviction is for the offense under section 436
the Indian Penal Code.
436.
436 is the major offense out of the lot, my lord.
Hmm.
451, 436, 427. But 436 is the main offense. And conviction is for
Oh,
five.
you wanted to show me the old book or something.
No, my lord, that is the case of 376.
Huh? That's another matter.
Another matter. That I have brought the old book.
I saw that old book. Yes.
Many times it has been used. Well, and here, there was admittedly some enmity between the informant and the
You were convicted under section 436.
451.
436 and only 436.
No matter. 451. Undergo arrive for 1 month for 451. Arrive for 5 years and fine of rupees 5,000.
For 436.
My lord. And with regards to 427, arrive for 1 month.
5 years is the problem.
My lord, 5 years is the problem. And I was verifying from the LCR because it was allowed on the last occasion.
And confirmed by the appellate court.
My lord.
Confirmed.
Here, my lord, he is in custody around 3 months. He was, my lord. And my lord, the house in fact, it's a case of 435, but has given a color of 436, if it will be accepted as it is. But it alleged that the date of occurrence, that is in the year 2010, March 2010, the night the informant woke up and saw that the petitioner is setting fire to his 2 motorcycles and the thatched house. And admittedly, my lord, they had some sort of animosity with regards to marriage. Marriage proposal that was failed, and petitioner was working under one Mr. Raut, with whom daughter of the informant is about to marry, that marriage could not be materialized.
No, this was an house or not?
The thatched house, one thatched house, but no seizure list is in that respect, and it is a half-born 2 motorcycles. 15 years back, my lord, what I am proposing,
minimum sentence?
instead of, yes, my lord, some fine amount was 5,000, it may be enhanced to 10,000 or 15,000. That will, I think, suffice the purpose after 15 years. Huh?
Life imprisonment may be extended.
436, my lord.
Either distribution. Minimum is not prescribed.
Minimum is not prescribed. Highly clear.
Yes. And then 5 years. Undergone is 3 months only.
Around 3 months, my lord. I was verifying from the LCR. From 9/3/2010, he was in custody till 24/5/2010, and after the judgment was delivered, he was taken to custody on 4/11/2011.
How can you convert it to 435? Just think over.
435, my
Can
lord.
show me something that we can convert to
My lord, 435 with regards to mischief by fire or explosive substance with intent to cause damage to amount 100 or aggregate product 10 rupees. When commits mischief by fire or any explosive substance, intending to cause or knowing it to be likely that he will.
Because here 435 sentence is up to
which
7 years.
Which can be extended to 7 years,
7 years.
and shall liable to be fined.
Here it is which can be extended to 10 years or life also.
My lord.
So that's the difference.
My lord, one thing I was.
If you can bring your case
I was
to
suggesting, my lord.
435, then we can alter the.
My lord, I was suggesting, my lord, that fine amount of 5,000 may be enhanced to 10,000 or 15,000, because that after 15 years for this offense, they must have been. I have not seen that client, or no, they are not turning up nowadays. My lord.
How can the sentence of 5 years be reduced to only fine.
5 years ballot has been imposed to considering ballot. They are in.
436 is very serious offense.
Yes, 436 is serious when considering say a big apartment has been set to fire. Here, the allegation is that
It is only saying
not on the
house
bedroom.
if somebody is
My lord
sleeping in a house.
will see the evidence of PW5. My lord, I'm not
Let's
able to
see
see.
PW5. Can it help you? Are you ready, sir?
Ready?
Are you ready or not? Don't argue half-heartedly. These are serious matters. If you are not ready, I'll put it. I'll not waste time.
Day after tomorrow.
After half an hour, if you say urgent, then it wastes of time. You collect it, all the paperwork and all, and try to address your arguments. Only instead of 436, let us try to make it out 435, so that the sentence could be reduced from 5 years to 1 year or something. You will finish it up. Concentrate there. You just see the other judgment and evidence also. We can convert. See, there is no much difference, 435 and 436 much difference. Only that is a house and it is, kind of open.
If it is human dwelling.
Human dwelling, whether it's something from the evidence you could get it.
Dwelling house.
Dwelling house. That's the problem. Yes.
Well done.
Human dwelling. Give it first. When do you want to?
July.
Next item.
37.
37.
37, may I please your lordship?
Yes.
Conviction under section 47A of VR and Odisha. Excited.
Here.
3 years and 20,000 fine.
3
years.
And appellate court also confirm.
Confirm. But 2 grounds I am advancing. Chemical test has not been produced.
Incident of which year?
Incident of 15.
10.
2010?
Yes.
So,
Chemical
7 liters
analysis.
of ID liquor.
Chemical
report has not been produced. And the other ground is the seizure, factum of seizure has not been.
Okay. These are very vital.
These are 2 grounds I am advancing. And ground number B, C, D, and E.
So show me from the judgment if you 1 paragraph or 2 paragraph. Otherwise, I'll extend the benefit of section 4.
Yes, that is one of my ground.
That ground is accepted. Then why do you labor then? I'll do it, finish it up.
The thing is that your lordship may kindly see.
Are you aiming at an acquittal?
Acquittal may be too much ambitious. I don't know, but 2 grounds are very strong grounds. Factum of seizure, 7 liters of ID liquor. Roadside, while doing patrolling duty, they were found. And it could not be proved by the excise that it has been seized from the accused. That's a very vital thing.
That's right, but in an uncertain world, why should we be so ambitious?
Your lordship may set aside 20,000 fine and extend the benefit of
fine is 20.
Mr. Chinchad is very pragmatic.
That's right.
Most likely.
Okay. Section 4, very good. I'll extend the benefit of provision of open. Yes. Conviction maintained, sentence is modified, and section 4 benefit is yes.
38.
May I please the lordship?
Yes.
On the last occasion, the lordship directed on a state to file an affidavit.
For there's an orders.
Affidavit.
My lord.
What affidavit to what actually?
In fact, your
Which
lordship.
order I have said that?
No, your lordship has not passed that orders. The order was passed by Honorable Justice Sahu on 18/4/2023.
Right.
In a case, no certain seizure was there. They want to release that one, and I filed for compliance of the court's orders. I'm filing the affidavit. I'll also have a copy to my learned friends. Let it go tomorrow.
Affidavit is for what?
For compliance with this one court dated 18/4/2023.
This is arising out of a conviction.
No.
Then?
Seizures, my lord. They have come against the seizures for the release of seized items in a
Seized
evidence
item.
case.
457 CRPC.
Yes.
My lord.
What are the articles?
My lord, the allegation is against the wife of the petitioner. My lord.
Lord, so let my learned friend go through it, my lord. I'm sorry, they copied to him. My lord. Let it come after lunch or tomorrow, my lord. Sorry.
What is the stage of the trial?
Yes, that instruction notes I was trying to ascertain.
What is the stage of the trial?
My lord.
What is the stage
What
of
is the
the
stage
trial?
of the trial?
No instruction, my lord.
That's the very important
Yes,
thing to know.
You're also changing the issues. What is the stage?
Because if you are acquitted already, it will be released. If you are convicted, some order might have been passed. And 457 doesn't lie. Why we are struggling, I don't know.
I will take instruction, my lord.
If the trial is at a fake end, I will not entertain and leave it to the trial court, because if you are acquitted, everything will be released in your favor. If he is convicted, seize property, they will deal in accordance with law. 457 doesn't lie. So let us know when this matter is pending since
Says 7/11/2019, the last order. was passed.
2019. By now, trial might have been concluded or about to be concluded.
I will take instruction. We both will take instruction.
So why unnecessary we are struggling in this?
But
we leave it to the trial court.
But for compliance of court, I'm filing the affidavit.
You file it, give a copy, but
Also to me, my
I
lord.
need
But
not,
we both will take instruction.
none of us required to go into all this thing.
Correct, notes.
Trial court conclude hoji, but we leave it to trial court to deal with that. Very simple. Please get the instruction. Supply a copy in pursuance to the direction of the court dated 18/4 to the whole difficulty is we are unnecessarily getting into
This exercise not German to the issue involved in this.
not at all
I
necessary.
agree with the lordship.
Unnecessary filing affidavit, this, that.
So many
Why
exercises, but not pertain to German to the issue involved.
Allegation is against the wife of the petitioner, my lord.
I'm not on the
My lord.
Stage.
You have moved an application under 457 for release of something.
My lord.
Which were seized. If the trial is already about to be concluded,
Forget
the
about it.
trial court, if you are acquitted, everything will be released in your favor. If the trial court convicts you
Vice versa.
under that provision, the seized article will be dealt with in accordance with the law. 457 doesn't lie. 2019 application. By now, trial would have been concluded also.
We both will.
Why unnecessary struggle?
My lord.
Madam, in pursuance to the direction dated 18/4/2023, Mr. Das and counsel for the respondents have filed an affidavit which is taken on record. Copy of the same is supplied to the counsel for the petitioner, and the parties are directed to inform the court regarding the status of the trial on the next date of hearing. Leave the matter on Friday.
What's your fixing?
Friday, half day, but small matter, they will say I'll be.
Friday, my lord.
Friday.
Friday.
To date.
I'll just ask.
Oh, bless me.
Which is your matter? Can I come within 5 minutes?
Yes.
I just come. I'll take just 5 minutes.
Title
so far the judgment of the impugn orders, it's not clear to me. I'll go through your lordship brief, my lords.
That's
It
also
will go-
my problem. also.
Let it
My
remain.
transport-
Let it remain in the board. We'll just check it up.
I'll just go through lordship brief,
Yes.
so I'll get the pen drive and all.
Yes.
It's not visible.
You see the court file,
I
and
think
if you
I'm
want
not-
to take a copy, you can take it.
Or I can take.
My copy also equally bad.
You just check it up. Take, get the pen drive and take it. I think. Let it remain. Okay, next.
40.
Let's say I am on VC, let's say.
Will you take it off tomorrow or next week?
It will remain whenever you are ready. We'll take it up. Yes.
40.
Let's say I am appearing on VC, let's say, plus the item 40, let's say I am praying for 1 week of time, let's say. This is old matter. We are not able to trace the file, let's say. Praying for 1 week of time, let's say.
You have short time many times. Just see, it was listed listed on March in the year month of March, again in April.
This
Every
is
time
the
you
last
see
chance.
time.
This is the last chance. My senior will appear in this matter. And last week, 1 week of time, let's say.
This is arising out of a conviction or what?
Arising out of conviction matter, let's say.
In the last two occasions, the petitioner, counsel for the petitioner has short time for short time. No, short actually. And today, when the matter is taken up, once again, another counsel for the petitioner seeks the time to reconstruct the file which he has misplaced. By way of last and final opportunity, the matter is adjourned to 2 weeks for cognizance. And it made clear that no further adjournments are being granted. Yes.
41.
Much obliged, let's say.
41. Yes.
Revision was the
Yes, what is this matter is about? Lina, senior counsel. Lini Mishra.
It's a Section 7 trap case.
Hmm.
Criminal revision has been tagged with criminal appeal.
Criminal appeal also.
Yes, ma'am. The sub item.
Yes.
One
What is
criminal
this
appeal.
revision? What is this revision?
Yes, revision, Mr. Das will appraise minutes.
Yes, revision is?
Three sets of lawyers at there.
No, there is a revision, there is an appeal. I believe the revision must be an interlocutory stage.
Sub item criminal appeal is appearing.
Yes.
Maybe a fixed date for hearing. The other
Date
criminal
today is
revision.
for hearing only.
Only hearing the fix your good day matter as to good ready.
Let it be there on the board then. You get it?
Yes, yes.
Okay.
Yes.
May I suggest this may be taken up in the weekly list so that it will come chronologically.
Weekly list.
Weekly list.
Yes.
It's a weekly
It
list.
is there. Whoever is ready will take it up, and because it is 2010 matter.
Yes, madam.
And tomorrow I'll take up the appeal
Appeal first, yes.
Because 92.
Yes, even 90s, madam.
90 is
Yes.
92. Well, let us give importance to those
Yes,
matters.
yes.
At least from 90 to
2000 at least.
we'll give importance to
Yes,
those.
madam.
Okay.
Yes, yes, yes.
But get ready, it is there whenever you
List.
yes. And if you don't, you lost the paper book or whatever, get the pen drive and take from the registry.
Well, here paper book is available, madam. Paper book is available.
Okay, next.
42.
Let it be. No, let it remain.
Well, this is 498 323 conviction.
Yes,
Matter has
madam.
been settled.
Matter has been settled.
Long ago they have settled and now they let us know. So we want to take instruction from them.
It is arising out of conviction.
Conviction.
Conviction. 3 years rigorous.
Yes, 498, 323.
Husband.
Husband.
They've settled, let them move application.
That's all.
Move application.
Settlement में पानी petition दूंगा.
I will help.
You move and land counsel for the petitioner submits that the parties have settled their dispute and she wants to move appropriate application before.
No, not fine. Appeal matter. It is revision matter. They have to file affidavit before it.
No, move appropriate application and affidavit.
Affidavit.
Let
So
them
that
file
will-
whatever will deal with it.
Affidavit file
1 week.
usually and
You move, get the affidavit.
Joint affidavit.
Application. We'll see.
ना अलग अलग बाहर जाइए
इसको जैसे document कर दो ना
Corrigi taku somebody has given a judgment today.
Correct.
If in a 498 case, if they have settled their dispute, acquittal can be recorded.
My lord, that is true, my lord. But in fact, my lord, we do not know whether the attachment settled or not.
Therefore, I am giving, let them file affidavit, record an acquittal. Yes.
43.
Yes, 43.
Yes, sir.
Yes, Mr. Mishra.
Day after tomorrow, my lord, I prefer.
Why
File
it is
is
not auspicious for you?
File is not with me, my lord. I will take a printout.
4 weeks. Why 4 weeks?
संबलपुर में मानी
Sambalpur, how far Sambalpur?
ସେମାନେ ଫୋନ ହିଁ ଠିକ ସେ ଉଠଉନାହାନ୍ତି ସେ ପୁରା ଇଲିଟରେଟ ଲୋକମାନେ ତାଙ୍କୁ ବହୁତ କିଛି କନଭିନ୍ସ କରିବାକୁ ପଡୁଛି
You need not convince. Then I'll dismiss the revision. Then everything will be convinced. Take it 2 weeks only. 2 weeks.
Let it come tomorrow only, my lord.
Tomorrow. What is this matter is about? You tell me first.
The file, sorry, my lord. File is missing. That is the whole problem.
47
Let it remain.
Yes, sir.
I'm not saying anything. Let it remain in the board.
Tomorrow, my lord.
It is there in the board. You get
Okay,
ready
sir.
and come.
Yes, my lord.
44.
I'm not passing any order. It will
Right.
remain in the board.
Right.
You get your pen drive, take
Yes, madam. I am
the
having-
file and get ready. Yes, 44.
44. But 44 or 45? Mr. Starting my lord, approach my lord, can take care of
44, 45. Remain. Let it remain. Yes. Next. 46.
46.
Yes, my lord. I presume. 46, my lord.
Yes.
Conviction is against the revision is against the conviction under section 47.
Yesterday, this matter before Lordship, my lord.
Hmm.
But what happened is sentence 1 year RI and 2000 fine. 47 we have Excise Act. They have stated that the IO of the PDOL 2 of PDOL 1 and 2, they have examined this case since the independent would not supported the case. But my submission before I received that on the seizure list has already been proved as annexure exhibit 1, and the accused, so also both the petitioners, the accused and also the witnesses, they have signed in the seizure. Seizure has proved, and also the
What is the sentence?
1 year, my lord.
PO. Chalo. PO. Liख दो ऊपर. Probation of offenders. Allowed. Conviction maintained. Sentence. ठीक है.
Judgment has
Judgment. The only problem is the workload is now immense because even for giving PO you would write a judgment.
My lord.
That's the problem. What to do?
Revision was said. Opulent is separate, revision of revision.
Note down, huh? Note down appearance and PO. 47. Yes, madam.
My lord, in this matter, the petitioner was convicted for 3 years, rigorous by trial court, and then in appeal, his sentence was reduced to 1 year,
1 year.
rigorous.
Offense?
324 IPC.
Yes.
My submission before my lordship is that the main ingredient of this section is the weapon. And in this case, the weapon was not seized. And also
Show me the statement. Show me the statement injured statement of the injured, and what are the injuries, and medical evidence corresponding to those injuries or not. Recovery is one part. Okay, that's the point I have taken. There is no recovery.
as to the number of, yes, there is no recovery. That
What is the
the
nature of
judgment.
injuries? Let us see.
As to the number of injuries, the injury is simple.
Simple, therefore
injury, yeah.
323.
Yeah.
My lord, can
As to the number of
see, my lord,
pictures-
page 11. Page 11, my lord.
11 of
my lord, the judgment of my lord of
appellate court.
No, my lord, trial court, my lord.
Right.
Running page 11. Paragraph 6.
Madam, are you ready perfectly?
Yes.
Ready, or you want to prepare?
No, I will.
Ready? Okay. Sorry. Yes.
11.
Eleven.
The number of
Yes.
May I continue?
Yes, yes, of course, why not?
As to the number of injuries,
Confident, why not? Yes.
as to the number of injuries, in the cross-examination, PW1, the informant, he,
Paper book do.
in LCR, it is in page 133. The
Barcode. Not LCR.
Okay, yes.
in the cross-examination, the PW1 informant reveals to have got 3 injuries.
Three?
3 injuries.
Yes.
And the doctor treated him for those injuries, and the same doctor prepared the injury report. And the doctor, in the report, doctor indicates only 1 injury. Injury report is in page 146 of LCR.
Injury?
Injury report is, medical report is in page 146 of LCR.
146. Forty-six of the paper. 146 of where? Who is injured?
The informant.
PW1.
PW1. Read PW1 first. Come to PW1. PW1 testimony. Read.
It's in the LCR. I have not got the scan.
Sorry?
I have not got the copy.
That's right. You take get the pen drive, take the entire set. See, in 326, 324 or 307 or 323, whatever, the injured witness is very important. And you have to see what the injured witness is. Thereafter, we have see the medical evidence. And we find out what are the real nature of injury. Thereafter, we should proceed.
All these are in LCR. All those are recorded in LCR. So
that's what read. Then read. Come to PW1 deposition.
I have not the hard. I don't have the hard copies.
Pen drive it. You get a pen drive and take it. Take it.
I have taken, but now I don't have the hard copy to read.
I know that. So therefore, you get the pen drive. I'll keep it in the list itself. Get ready, and whenever you get ready, I will do it. Okay. Okay. Let it be there on the list. Okay. Yes. Next. 49. 49. Jane Podda. 40, 50.
50. 49, madam.
Let it remain. Yes.
50.
Next.
52, 50, 51, 52, my lord. My lord, I have to take the valid of the LCR from the court, my lord, since no copies are for the that
50, 51 and 52, na? Mr. Ragada, legal counsel for the petitioner, legal counsel for the state submits that doesn't have the copy of the paper copy you don't have.
No. It was served earlier, but might be missing.
No, my lord, it's served in the office, my lord. That is not available in the office, my lord. 50, 51, 52.
Shall I direct the registry?
Directed to supply.
Registry directed to supply a copy of the paper book to the copy of the petition along with the annexures to Mr. Ragada. 50, 51 and 52. 53.
54.
Yes, sir. 54. Yes.
This is the revision against conviction under section 498A.
Yes.
And sentence for 3 years, Miller. And fine of rupees 1,000, Miller.
Argument.
already admitted, my lord.
Husband.
Husband, my lord.
Yes.
In view of the fact that other relatives they have already been accused, my lord. Only husband has been convicted for the offense under section 498A.
Yes.
Here, my lord, the marriage of the informant, that is PW3, was solemnized in the year 1999, my lord. Complaint case filed after 7 years, my lord. After 7 years.
But allegations are.
Allegation is that, my lord, the present petitioner brought
Maybe the allegation is within that 7 years, then.
after 7 years.
No, allegations are made after 7 years, but when the torture has taken place, when?
Not torture, my lord. Allegation is that, my lord, the petitioner brought the sister of his wife, my lord. This is the allegation. ତା ଶାଳୀକୁ ଆଣିଲା ରଖିଲା.
That case, Lordship.
That case,
once
in that
ask
case,
him to bring the sister-in-law so that the matter will
she
discuss.
is not coming. ସେଥିପାଇଁ ତ notice ବି ବଢିଆ.
Robbed his wife and
Robbed
taken
his
the sister of the wife with him.
One son and one daughter, my lord. They are staying, my lord.
With the sister-in-law.
No, my lord. With his wife, my lord. Now they are residing, my lord.
What happened to the sister-in-law?
Sister-in-law, as per instruction from the learned council in the court below, my lord, she has married, my lord, and staying somewhere. ରହୁଛି ଏବେ ବି ରହୁଛି
Both
ଦୁଇ ଜଣ
of them residing with him. ଡାକିଦେଲେ ସରିଯିବ ଗୋଟେ।
ଡାକିଦେଲେ ଆସିଲେ ତ କେମିତି କରି ଡାକିଲେ ଆସିଲେ ସରିଯାନ୍ତା।
Conviction under
498 my lord.
Probation କରି ଛାଡି ଦବା ଯାହା ବି ଶୋଇକି ରହୁଛନ୍ତି ତ ରହୁ ଜେଲ ପଠେଇ କଣ ମିଳିବ? Probation କରି ଛାଡି ଦବା। You enjoy your life with two wives. That's the best way of do what to do. Probation କରି ଛାଡି ଦବା। At least conviction maintained, sentence modified.
ଚାକିରିଆ ନୁହଁ। Driver, he is a driver.
Chakri hale bhi you are luxury having two wives, then you have to face something. Where is that? Where have you said that the wife is there? Anyway, they are staying together. Shall I record that both of them are?
Yes, madam.
Huh?
Both are residing. Mane
With the
sister-in-law also reside.
That the petitioner is now residing with PW3 is the informant.
PW3 is the informant.
His wife, PW3 and
today's my lord. PW3 is not
sure
pure.
that their wife is residing with him. Not sure.
Yes.
Sir, PW3 is married another person from Ameen.
PW3 married. Sorry.
PW3 is the sister-in-law.
Wife. She has
Wife
remarried.
has married with someone.
Remarried. My lord.
And sister-in-law staying with
Staying with her. My lord.
Simply for fear.
So don't write it down. Try to create further confusion in their life. As it is there. The mess. Okay. Section 4 will. They do the case. Yes.
65.
Yes.
May it please your lordship. Conviction under section 376.
Yes.
Sentenced to undergo RI for 7 years. And yeah. Ragda bhai. Oh, Ragda bhai. Karo. Confirmed in appeal. Lordship may kindly turn to page 39 of the brief.
My lord, may I submit one thing? My lord, it's a case of 376 man. And with the age of a victim is 16 years, 2 months only. And also that victim was pregnant at that time and delivered a child on that October 1996, my lord. So, my lord, today, my lord, senior has given a preliminary note
point of
argument
law.
submission.
It will
So
take.
let me prepare.
It will take only 2 minutes.
Let us.
ଆଜ୍ଞା ଶୁଣିଦେବା ଆପଣ ଦେଖନ୍ତୁ
Yes,
ଦରକାର
yes,
ବୋଲି
yes.
submit
ସେ ନେବେ ଟାଇମ୍ ନେବେ ମୁଁ ଜାଣିଛି but my submission is your lordship may kindly turn to page
No, no,
13.
you submit my senior. I will try my
It
level.
is submitted third para
49
page 39.
13.
Trial court judgment hearing of the question of
It
sentence.
is submitted by the
It is submitted by the learned defense counsel that the convict is a young man of hardly 20 years having a long future and at the time of occurrence he was a juvenile.
Okay.
Your lordship got it?
Yes.
Thereafter, he has been sentenced to undergo RI for 7 years. Next page, para 25.
Did it submission only?
My lord. Your lordship may kindly see section 20 of the Juvenile Justice Act.
Can you tell me that how he is juvenile?
Yes.
It is your submission.
No.
But
It-
you, from record, you
Yes,
tell me that he is juvenile.
the charge sheet has been submitted saying that he was born in 1979. My note may kindly be seen.
Yes, let us.
Page 4, page 3.
Okay. Yes. Instead of submitting
7-2.
17.
The charge sheet shows the date of birth of Lakshman to be 1979. Occurrence took place in 1996. Section 2K of Juvenile Justice Act defines juvenile or child means a person who has not completed 18th year of age.
Right.
Section 20 reads, that is most important.
Right.
Notwithstanding anything contained in this act, all proceedings in respect of juvenile pending in any court in any area on the date on which this act comes into force in that area shall be continued in that court as if this act had not been passed. And if the court finds that the juvenile has committed an offense, it shall record such finding and instead of passing any sentence in respect of the juvenile, forward the juvenile to the board which shall order in respect of that juvenile in accordance with the provisions of this act, if it had been satisfied on the inquiry under this act that juvenile has committed the offense. Board is defined as means a juvenile justice board constituted under section 4. So once he finds somebody guilty, he has to forward it to the juvenile board. He cannot pass a sentence. That is what he has done. Let him take a.
No, my lord, in this type of cases, my lord, juvenility can be raised at any point of time. My lord.
In the
Now,
Supreme Court
if
also.
they would raise that point, man, they should have filed a.
No, it was raised before trial court. 30
Yes,
record.
Now, even if the trial court had not considered, my lord, then they have failed in the appellate court, my lord. Now they are raising the points at this court, my lord. Your lordship can direct the concerned district court, my lord, district judge, session judgment, session to inquire the matter. If he is found,
That has to go to the juvenile board.
No.
The law is very clear. And your lordship knows no more in res integra. Because Supreme Court has said at any time.
That can be done.
Yes.
That can be
At
done.
any time.
On the basis
Even
of
if it has not been done.
basis of rule 12, it has to be decided whether
Yes.
juvenile.
Two options lies with them, my lord. They can, my lord, the straight away the file application, they remitted back the case for to juvenile board for reappraisal.
Why don't you move an application then?
My lord, I have submitted before your lordship that they cannot pass such an order. Sentence cannot be passed.
Exactly.
The law is very clear. Statute says so.
It has to be set aside and remitted back to the
Yes, I don't dispute.
I
I
dispute.
Otherwise, but my submission is again further. My lord, conviction was in 2002. Appeal is since the revision is since 2011. Would it be proper?
Then you should direct the Lord Session Court to inquire the matter, and if found juvenile, my lord, then you
That is the charge sheet says he was born in
Charge sheet said, my
79.
lord, charge sheet has been submitted by the absconding to this petitioner.
Yes, but date of birth is 1979. That is their case, not my case.
I'll set aside and remand.
Whatever order your lordship pass, but this sentence cannot remain.
That has to be set aside.
My lord.
Remitted back.
Tell me when the incident is taken place.
1996. Both were in class 9. Both. The petitioner and the victim. They were in class 9.
You examine it. I don't want to see 1996 incident.
Yes,
You send it
that is what
and the trial court and
my lord, that will be my submission.
fruitful purpose will be served.
But fact remains that
No witnesses will be available.
But
They have to substantiate, either adducing evidence.
Do you have any?
my lord, it is their own case.
Forget. Do you have any certificate?
My lord, your lordship will kindly see. Both were studying in class 9.
I understand. Do you have two only?
Then I will bring. I will try to.
I will put it day after tomorrow. Bring some certificate.
No, not day after tomorrow. Next week.
Next week.
Because
Okay,
from the school he will bring it.
And you will
bring and place it.
Yes, my lord. My lord. My lord. Yes. Yes.
Get
my lord. Statutory provision that cannot happen.
If you get some certificate,
my lord.
If they file a charge sheet saying 17
my lord, my lord.
That will land corroboration to that. I
My
will take cognizance of that and set aside.
My lord, I will bring that.
Set aside and finish it.
My lord.
ଆପଣ ବି ଦେଖନ୍ତୁ I will set aside. He is juvenile under.
ମୁଁ ତ ସେଇ କଥା
Next week ଆପଣ date ଟେ କୁହନ୍ତୁ କେବେ ଆଣିପାରିବେ?
ଆପଣ ତଥାପି ଗୋଟେ ଡେଟ୍ ଛାଡିକି ଗୋଟେ ୱିକ୍ ଛାଡିକି ଆସୁ କାହିଁକି ସେ ସ୍କୁଲରୁ ଆଣିବ
ଆଣିକିରି ଆପଣ better that you move an application.
ଆଜ୍ଞା ଦରକାର
I'll take cognizance of that and set aside everything.
my lord, my lord.
Yes. Land counsel for the petitioner submits that admittedly on record it has come that the petitioner is an juvenile. He seeks 1 week time to 2 weeks time to file appropriate application in that regard. Section 12 on the basis of section 12. I'll just see. I'll take cognizance of that and finish. Yes. 56 months. Okay. 57.
Item 57, my lord, kindly taken up 1 week after, because it's a matter
It will remain in the board.
It's a matter of 2012, and we'll take instruction whether the petitioner is alive or not.
And counsel for the petitioner. What was the age at the time? Let us see. Everybody can't die. 51 at the age.
At that time,
in the year 2010. 51.
51, my lord.
51. So 2010 means now he must be 64, 65.
My lord.
Nowadays longevity is 90 years. Okay, when counsel for the petitioner seeks 1 week time to ascertain the status of the petitioner, leaves the matter after 1 week.
My
Yes.
lord.
The case palette which I was arguing with regards to the case of 376, whether maximum sentence provided, that is valid, that has been decided by our High Court.
The one which, what is the sentence about it in this case?
Valid, there is a proviso attached to section 376.
58, no? Sir, 58, sir.
That proviso says you are giving reasons, court can reduce the sentence.
From 3 years to
Any sentence.
now in this case 3 years.
7, valid, yes. Here valid. देखिए They say provided that the court may, for adequate and special reasons to be mentioned in the judgment, impose a sentence of imprisonment for a term less than 7 years. So that has also been considered by this court as well as
sentence imposed
3 years.
3 years.
Valid.
Without reasoning.
They say, well, considering the merit of the case and the fact that petitioner was in custody prior to that, 1 year and some more days, they have, court has considered in that way. But on merit also, I have got a case in the sense.
Incident of which year?
The incident is of the year 2006, 2004, valid. 2004.
Hmm.
My lord, what has actually happened in this case, the case of the prosecutrix was, she was coming from a crusher where she was working as a laborer, and on the way, petitioner met her and asked her to take.
No, yes, you argued that.
My lord.
The-
So on merit also,
And see,
my lord, I have also brought decisions to the effect that if the prosecutor was version of the prosecutrix is not above board,
right.
that is there also by the apex court, and also less than the prescribed sentence can also be imposed considering the facts and circumstances of the case. Here, my lord,
Where is that?
my lord,
We are trying to find out the way out
my lord.
or to
Here is a case by honorable
alter the
justice.
sentence to already undergone.
My lord.
1 year or something.
My
you
lord,
have
my
already
lord,
undergone.
my lord.
Where is that?
Here also by honorable justice Krishna Iyer, in his usual way, my lord, the here the sentence was 4 years before the apex court, and the court has reduced it to 2 years.
That is the 142. They have 142 power.
No, they have not stated about 142. Yeah, not a sentencing process should be psychosocially oriented and have a reformative and therapeutic goal. The usual language used by.
That therapy is all right, but within the parameters of law.
My lord. No, they have considered it. That has been considered by this honorable apex court. Another judgment, my lord, of the apex court, 2019, volume 15, SEC 566. There, my lord, testimony of prosecutrix held, though evidence of prosecutrix must be given predominant consideration, but to hold that this evidence has to be accepted, even if the story is improbable and belies logic. Because here she says, when I was taken by the accused, 2 persons were there, but they have not been examined. She was working in the crusher and she was returning from the crusher, and she has stated that I used to sign in the crusher register. That register has not been produced. She says, I was taken to a house where I was kept 4 days, and each day.
And 4 people were there.
But none of them have been examined. But for considering, and the medical examination report says she was she used to sex, but no
ossification test report is not brought up.
Ossification test report has also not been exhibited. She has stated that on appearance, she may be 16 to 17. Father says 15 to 16. Mother says 14, like that, but at the age has gone. And bereft of everything, and this is a case of 20 years back. And
what is his age now?
Age would be, my lord, 55, 56.
Just see. Because in this case which you are citing,
22.
The court has taken into consideration the
age factor also.
60 years, and therefore the sentence is reduced down to all that are already undergone.
Here, my lord, would be around 56, 57. The question was whether it can be reduced or not. So it says it by giving some reasons it can be reduced.
What happened in this case, my lord? The PW8 is the victim, my lord. My lord, the last time my senior read 3 questions, my lord. Delay in alleging effort, that has been, my lord, the explained. Delay has been explained, my lord. Second question, with regard to age, my lord. Doctor said that within 16 years, and a father stated 15 years, and mother stated 14 years, my lord. So the father are, in the absence of ossification test, my lord, the father and mother is the competent witness. They can
any document in the absence of any document.
They can say the real age of the.
What will happen if there is an ossification test already done, but you don't place it on record and rely upon the oral testimony?
When that is not available, my lord, oral testimony, the father, mother is the best witnesses. They can say the age of the victim.
Perhaps
they have to caution.
Perhaps my Ronald has forgotten or has deliberately not stated. There is a off-quoted decision of the apex court, wherein it has been held by the apex court that usually parents gave a lesser date. Is what
he is conspicuously forgetting everything while standing in the other side.
That is 64 Supreme Court that usually we are citing that +2 and -2. Usually that is been given. That too, fathers and parents are always interested to give a date earlier to that one. And that too.
And a pedal. And some other would.
And that too, when DW1 and DW2, they have not been cross-examined at all by the prosecution. So whatever they have stated, that is to be accepted as it is, well, that enmity is there, and I see she has been.
Mr. Raghuda, by recording these special circumstances, I will reduce the sentence by taking aid of this judgment to that of the already undergone. That's the best course, I think.
My Lord may take note of. I have verified from the records on 5/6/2024. He was taken to custody.
1 minute.
5/6/2004.
5/6/2004.
And he was released on bail on 2/3/2005. And again, he was taken to custody on 4/5/2012, released 4/5/2012, and released on bail on 36/2012.
30th
June 2012.
So how much it is now?
Around 1.5 years, my Lord, I think. Sorry, around 1 year, 2 months or 3 months.
June 2004 March. 10 months, about 10 months. About 10 months. June, June will be sure.
5.
About 11 months.
7 months.
This is only 1 month.
Around 8 months.
11, 12 months, 1 year, roughly about 1 year. Roughly about 1 year. Special circumstances. And because this court relies upon that, and give that proviso.
Valid.
Earlier.
Valid.
Photocopy of it.
Photocopy date.
The fine imposed 5,000, my lord.
I'll increase it. 10. 10 and
Victim of Sibo.
That's good.
Victim दिया जो उनके victim Sibo कौन से बाहर फाइक बार चुरा था
और हेलो भी दे दो।
हाँ
10,000 टका कर दो।
आगे
लिखिए
वो तो जेरक्स कर दो फोटोकॉपी
कर दो ऑलरेडी अंडर हाँ जेरक्स कर दो एंड गिव दिस 10,000 ऑलरेडी अंडर 10,000 ऑलरेडी अंडर ठीक है चार्जिंग दे दो मैं बोल दूंगी 3 o'clock I'll get up and yes 59 this one yes related week 60
Anu ki actor my lord.
Let it be there let it be there 61 let it be there no problem 63 just check it up wherever there is the revision arising out of some charge order and all you must tell me so
yes.
that I can conviction I can't dismiss in default
yes.
but charge order and all interim order I can very well do it yes 65 65 right 66
Malad. Here, item 66, against the affirming judgment, conviction under section 47 of the Bihar and Odisha Excise Act. You'll also see the
Sentence?
trial, my lord.
Sentence?
Yes, you'll also kindly come to.
6 months and pay fine.
Lord, a trial court impose punishment of rupees 2,000, fine of rupees 5,000.
PO.
Yes, not a
PO.
appellate, yes, Lord.
I'm giving PO. Lead the judgment.
Yes, Lord.
My lord.
Provision of.
Man.
When
Dispose of.
Dispose of, huh?
Dispose of. Yes, man.
Yes.
67.
My lord, may I play one thing? My lord, item number 67 to 70, my lord. You'll also may kindly direct to serve the copy, my lord, copy.
57 to?
67 to 70.
67 to 70 good लिख दो, सब रोल का लिख दो. Mr. Rahul and Counsel for the State submits that he doesn't have the copy of the petition. The registry, I am directing registry to supply a copy.
Yes, my lord.
Registry is directed to supply copy of the petition along with the annexure.
My lord.
To Mr. Rahul.
My lord.
Lease the matter after 2 weeks. Yes. 70 Jengala.
My lord.
Next.
71.
May I pray, Lordship, on behalf of Mr. Barik, please 1 week after.
So let it be there on the board, huh? Okay. 72. Let it be there on the board.
73. 74.
Border of
75.
Yes.
May it please regards for that.
Yes.
Here, my lord, initially charge was framed for the offense of the section.
70. I don't adjourn.
You want to argue?
No, I don't adjourn.
It's already, it is there on the board. It's not adjourned, there on the board. You prepare and come. Maybe taken. Yes.
My lord.
75.
My lord. Here, my lord, initially charge was framed for the offense under section 452, 376 by 511 of the Indian Penal Code. But during trial, petitioner has been acquitted from the charge under section 452 and 376 by 511, but convicted for the offense under section 354, 452 and 354 of the Indian Penal Code, my lord. Facts of the case is that prosecutrix is a married lady, my lord, having 2 children. It is alleged that on the date of occurrence, that is 20th September 2005, taking the advantage of the absence of her husband, while the informant was sleeping, my lord, and the night it is alleged the petitioner entered into the house and tried to outrage her modesty or attempt to commit rape, my lord. It is alleged that he raised halla, for which, my lord, the 2 children and the husband, they came, and petitioner was locked up, or he was bolted from outside of the room where he has entered. And some villagers, they reached there. It is further alleged that one of the villagers, they intimated the police. Police came, took the petitioner to custody. But the peculiarity of the case is, though, my lord, it was alleged before the investigating officer that petitioner has done this heinous act and he was taken to custody. But the case of prosecution is, on the day, we searched for the petitioner. We got him the next day. We lost the information at around 10 a.m. next day. Police came and affair was lost at 11 a.m. Investigation was
What are
started.
the evidence of the villagers?
My lord.
They controlled him and given.
My lord. My lord. I think my learned friend will also agree that part is how, my lord, if law is very clear that when an information police investigating officer or police officer received with regards to any cognizable offense, that is to be registered first. Basing upon that registration, basing upon that initiation, he or she can go for investigation. Here the allegation that I was taken from the house of the prosecutrix to the police station. And the next day, FIR has been registered. So that information which police received and came to the house of the prosecutrix, that should be the first information matter. That has been suppressed. The next day, my lord, prosecutrix says, I lost that information. Basing upon that, investigating officer came and done all these things. The basic foundation structure, my lord, that has been collapsed. Court has disbelieved the evidence of prosecutrix with regards to 376 and 511, but convicted for the offence under section 354 and sentenced him to order for.
One evidence of any villager.
Well, I am ready. My lord, may kindly see evidence of PW3. Occurrence took place on 20th September 2005 in the house of the informant. I reached at the spot at about 2:30 a.m.
But there is no LCR.
LCR must have not received.
Not.
My lord, I will give copy. I've got the certified copy.
Get the LCR. Let us get the LCR.
My lord?
Let us get the LCR. Let it be there on the board. Write down. LCR in the present case is not yet received from the board below.
Scan copy.
Scan copy. Scan copy. Scan
Scan
copy.
sanction.
Scan copy of LCR. They is directed to call for the scan copy of the LCR from the board below. Forthwith. Let it be there on the board.
My lord, fix up a date next week.
Next week. And 76 also the same order. LCR is not received. Same order. 76 there is no LCR. Scan. Yes. 77.
77. $78.
79.
79.
Necessary for LCR, my lord. It is offense on 376, my lord.
LCR is not there. 79, na?
My lord.
LCR is there.
Yes, my lord, and pen drive to copy.
Yeah, pen drive to copy. Take it. Let it be there on the board. Yes. Take a copy.
My lord.
80. Let it be there. Take it.
81.
May I please, Lordship?
Yes.
Lordship, this is the confirming judgment except of offense under section 341, Lordship. Charge sheeted under section 294, 341, 325, 323 and 34 IPC.
Sentence to?
And in trial court, 294 by 34 is acquitted. That is narrated in paragraph 8, Lordship. And convicted under section 341, 325 and 323. And the appellate court confirming all these sentences except 341, Lordship.
Yes. What is the substantive sentence?
That is, Lordship, 2 years.
2 years.
Yes, Lordship.
Ready?
Yes.
Yes.
May I please?
You are
Lordship,
ready?
yes, Lordship. Lordship, the informant is the victim's wife, Lordship. An allegation is that on the date of occurrence, while the victim and another person returned from the jungle to collect some firewoods, at that time, this accused and along with 3 other accused persons, they obstructed the victim and assaulted them. That is the allegation, Lordship. Lordship, kindly there is only one eyewitness, that is PW6, and PW7 is the IO, and PW3 is the victim, Lordship. And PW2 is the informant and PW1 is the doctor, Lordship. That is the contradiction between the PW3 victim and PW7, that is IO, Lordship. That is narrated in the page 7, trial court judgment, Lordship.
Yes. Para?
Para, Lordship, that is, there is paragraph, first paragraph, Lordship, that is 11, running.
Yes, reading.
I am placing the operative portion, Lordship. That is 7, page number 7, Lordship. Here, accused Thuruda, may I, Lordship? Thuruda dealt a blow causing the aforesaid fracture, but all the accused persons are voluntarily liable as per the provision of section 34 IPC for having common intention to cause grievous hurt to PW3. During cross-examination of PW7 IO, the defense has brought about a contradiction to the effect that PW3 has not stated to the IO the accused Thuruda has assaulted him by means of handle of a tangia in his right hand, causing fracture. But he has stated that all the accused person assaulted him by means of a body and a handle of a tangia, causing injury to his face and body and caused fracture on his right hand as reflected in his previous statement made before IO. This contradiction in the evidence of PW3 opined out by the defense does not affect the substratum of the prosecution case, particularly when it is proved that in furtherance of their common intention, all the accused persons assaulted PW3 by means of lathi and handle of a tangia. Lordship, kindly glance at the deposition of the IO, that is PW7.
He might have said that none of them has beaten, only the Trudeau has beaten.
Pardon, Lordship.
IO might have said that Trudeau has beaten.
Yes, Lordship. No. That the victim has not narrated before the IO that Thundo has assaulted him.
Okay.
And Lordship, that is PW7 evidence, deposition of PW7, that is IO, Lordship. That is the cross-examination of defense. I have not examined scribe of the affair. I have not seized any incriminatory object like tangia from this spot during my visit to this spot. There was a counter case against the husband of the informant by accused of this case. No weapon has been seized. There is no weapon, Lordship. And Lordship, kindly glance at the PW6, who is only the eyewitness. May I place it, Lordship?
Yes.
The informant is my bhanja. I know all the accused person occurrence took place on 6th December last year at about 6 to 7 p.m. Krishna and myself had been to jungle, while myself and Krishna were returning with one balla, each on our shoulder. Thunda told this some slang language, Lordship. Telling so, Thunda dealt a blow by the blunt side of the tangia on the right hand of the Krishna. Out of fear, I laid this spot and informed the matter of Bula, Biranchi and Pankaj. I, along with all the accused persons, 3 persons, went to Moja Sripala and found Krishna sleeping on the mandap. Firingi police came and took Krishna. Yes. And Lordship, at the time of occurrence, 500 people are there, but no one was examined.
Got 500 people.
That is, Lordship. That is, Lordship, PW3, who is the victim, deposition of the victim.
But how will you get over this corroboration of evidence of medical officer to the injured witness?
That is presumption, Lordship. Lordship, can you glance at Lordship PW1?
Injuries are there.
That may be, Lordship. Kindly glance at PW1 statement, Lordship.
Merely because there is no recovery, how can you disbelieve medical officer's evidence?
Lordship, that is injury 1 and 2. He submitted that injury 1 and 2 are the simple and 3 is the only the grievous. Lordship, kindly glance at 3. That is the deposition of the PW1.
Come to para 11 of trial court judgment.
Para 11 years. Yes, Lordship.
Yes. To prove this offense.
To prove this offense, I have gone through the evidence of medical officer PW1. He has reports that on police requisition, he examined one Krishna Sahani PW3, who is the victim, and found following injury on his person. On his person's Lordship. That is lacerated injury of size 1 inch into half inch and 1/4 inch on right cheek below outer angle of eyelid. Second one is bruise of size 1 inch into 1 inch on left shoulder area. And third one is bruise of size 3 inch into 2 inch on the right forearm. Injury 1 and 2 are simple in nature. PW1 has further opined that all the injuries can be caused by blunt force. Age of the injury was within 6 to 12 hours from the time of his examination. On further perusal of the evidence of PW1, I have found that he advised the injured PW3 for X-ray examination to ascertain the nature of injury. He has proved the injury report Exhibit 1 and his signature thereon as Exhibit 1/1. His evidence also indicates that he has perused the X-ray plate produced before him by the IO PW7 to opine nature of injury. Number 3. He has stated that in single plate, there were 2 X-rays. The number of X-ray plates are R2314P and R2315P. The X-ray shows fracture of both the bones of forearms. Injury number 3 of Exhibit 1 is grievous in nature, which might have been caused by direct blow. He is not sure of that, Lordship. And his deposition, he also...
How much you have already undergone?
Now I am on bail.
Undergone, period of undergone.
Lordship, I will take instruction for that.
You see the record. Period of undergone, just tell me period of undergone. We can think of converting it to 323. Because there are 3 injuries. 2 injuries are simple in nature. Third injury, he says that it's grievous in nature. Third injury is bruise of size of 3 into 2 on the right forearm. That is also, according to me, is kind of a simple injury.
And that maybe he also narrated that the injury number
that he is doubtful about it.
Yes, Lordship.
So we will say that all 3 injuries are simple injury, 323, not 325. And sentence reduced to already undergone. You tell me how much sentence you have already. I have heard you, I understood you. Now, from the record, you please wait in the lunch time, just see. Already undergone and tell you. That's best way. 323 is a case of 320. Yes. Any mentioning?
No,
Item?
Item 83.
83, right.
Adjournment and no, LCR will be supplied.
LCR copy you take from
Yes,
yeah.
Pen drive.
Okay. Okay. I don't know, 70? It will remain in the board.
83.
I'm not adjourning. It remain in the board. You get ready whenever you're ready. It will remain in the board. Huh? No, 81 she will tell.
83.
He will tell what is simply yes. 83.
70.
It will remain in the board, sir. You get the pen drive and
Yes,
get it from here. No problem.
Yes,
73 after launch fill up.
73.
It has been passed.
It will remain in the board. It will remain in the board. I'll exhaust the board first. It will remain in the board tomorrow.
Then let it come on tomorrow.
Yes, it is there.
All right.
And till 86 it remains no. And from 87 we will take up.
83 to 86.
From 87 I'll take it. Take up. 85? Huh? 85?
Mine is item 94. Conviction of this decision.
Wait. When it will be taken up, I'll see what is this matter. Because these are the matters of 3 decades, 4 decades. Okay. So in the display, item number 87.
87
Onwards. From 87 onwards. Only 29 days.
Pure set.
Huh?
Pure. Profession of nurse.
Probation.
323 korgi.
Medical report is there.
323 korgi, what Mr. Ragada says is 323 convert korgi. Pure Shardava. Incident of which year?
That is 2006, Lordship.
Huh?
2006.
What do you say?
That's it. Oh. It told me to
Huh? Of the pure body. In 29 days you have already undergone. We can't reduce.
Progressively on the.
See, there are 3 injuries. 2 injury doctor says simple. Third injury he says grievous, but third injury is only arm bruises in the arm.
Both.
So therefore it should be a simple injury only. But I can't substitute to the opinion of a doctor.
Yes.
Doctor says grievous means it's grievous. I can't say that it's simple.
Only expert.
That's the expert witness.
Only expert.
And purported
323. 323 convert and extend the benefit of probation of. ठीक है, इसको भी दे दो भाई. लिखी हो तेरे. Conviction converted to 323 and चलो ठीक. Yes, pass over.
Highly obvious, Lordship.
21.
21.
This- Item 21, my lords. This pertains to a DA case, my lords. The accused was excise inspector, and this revision, my lords, is directed against an orders refusing to return the seized money. The impugn order dated 2003, 25/4/2003.
No, what was the impugn order?
Impugn order is 25/4/2003, by which the London CSM in a vigilance case pertaining to DA case, my lord, of the accused was an excise inspector. The application for return of seized money was turned down. Challenging that thing has been brought.
Petitioner has challenged the order dated 25/4/2003 passed by the CJM Cuttack,
Yes.
whereby the application moved by the petitioner for
return of the seized money.
For return of the seized money has been turned down.
Turned down.
Turned down. The revision petition is pending since.
Since the impugn order is dated 2003,
Pending
and
since
the
2003.
PSK is dated 22/88 votes.
Revision case, the present revision petition is pending since 2003. When the matter was taken up on
After a decade,
20th June 2024. None appeared for the petitioner. When the matter is taken up today, nobody appears for the petitioner. It seems petitioner is not interested to proceed with the case according to this distance. Yes.
22.
22, this pertains to another application, lords. This pertains to 846. It would, my lords, this is an orders by which the charge has been framed. my lords.
Right, the petitioner.
charge has been framed.
Petitioner has challenged the order dated 1/10/2005 passed by letter special judge vigilance in
Framing charges.
In TR case number 26 of 2002, whereby charges
Have been framed.
Against the petitioner has been framed. Framed. Was there any stay in this case?
No, in the absence of any stay,
In
after the framing
absence-
charge, the
in
trial
the
begins.
absence of any stay order passed by this court, the trial has proceeded. Trial has proceeded. When the matter was taken up on 1/7/2019, none appeared for the petitioner. None appeared for the petitioner, and subsequently, on 20/20/2024, also none appeared for the petitioner. When even today, there is no representation on behalf of the petitioner. Therefore, it seems petitioner is not interested to prosecute the case. Accordingly, it is dismissed. Yes.
28.
Yes. What is this matter about? Challenge to
My lord, 395 sentence, 5 years, my lord, and fine rupees 1,000. My lord, that matter, which matter your lordship has directed, amicus curiae was appointed, and then thereafter the petitioner has approved this court.
Thereafter, who appeared?
Bikram, the original advocate, my lord, Bikram Chandra Ghade, my lord. And he was directed to serve the copy of deposition in the last occasion.
Now, where is that order? Last order to me. Why is this not scanning? Scan. No, this is scan. This is direct to supply the copy to Mr. Sahu. No, he says that thereafter only urgent. Who appeared? Right on. None appeared on appeared for the petitioner on 2/4/2024, and on 8/4/2024. Therefore, this court appointed Mr. T.K. Sahu as amicus curiae to assist the court. Assist the court. However, subsequently, when the matter was taken up on 21/6/2024, Mr. Bikram Chandra B.C. Gadai appeared for the petitioner and submitted that he would be arguing the case. Therefore, the amicus curiae who was appointed in the previous day did not recuse. The previous day did not appear. However, when the matter is taken up today, Mr. Gadai has not appeared. Therefore, I revive the order dated 8/4/2024, appointing Mr. T.K. Sahu, learned counsel, as amicus curiae to assist the court, leaves the matter on submission. Next, because inform T.K. Sahu. Registry is directed to supply the copy of the paperwork to Mr. T.K. Sahu. Yes.
34.
May I please, your lordship? I am filing a written notes consisting of 2 pages along with 3 authorities, my lord, for your lordship's kind perusal.
Yes.
I'm also serving this and my lord. Here, my lord, the petitioner was arrested while he carrying 20 liters of ID liquors in a bladder, and it was loaded in a bicycle. Then after filing of the arrested and subsequently was released on bail, thereafter he faced the trial.
What are the judgment? What do you want to
2 years. 2 years conviction under section 47A of the Orissa
where
Right. What are the judgment?
judgment I have given, my lordship, may see 3 points. I have only 3 short points. It is admitted that no
Judgments are for what?
judgment are because the material which was seized, the ID liquor as well as the bicycle were never produced before the trial court. And secondly, that the hydrometer as well as blue litmus paper test are not the sure test to come on a conclusion that is ID liquor, and there was no chemical examination report at all. On basis of that 3 judgment I have given. In all 3 judgments, the order of the Lord.
There is no chemical.
No chemical examination. On basis of blue litmus paper test and hydrometer test and experienced that IO, this judgment is based on. As a matter of 2009 trial, then I carried to appeal to the
Incident taking place when?
in 2009.
Yes, Mr. What do you say? No chemical analysis report.
Hydrometer is also evidence for the chemical test because it is the quite chemically. Litmus paper and hydrometer test has been given. Accordingly, the
I'll grant
question will
PO.
come up.
What is it?
Lordship.
Huh?
Lordship.
Grant PO, finish it. Conviction maintains PO again. Excited.
Obliged, madam.
PO. Record रख दी दे दी PO. लिख दी ऊपर. Appeals now.
We are item 87.
Yes, 87. What is this case? 1992.
Yes.
On 1/12/2023, nobody appeared.
And it's on 4/1/24.
And 1/10/10/2023, nobody appeared.
No.
Okay. And
last list हुआ था 4
and on 1/4/2022, nobody appeared.
Last it was listed on 4/1/24.
4/1/24.
And we were in fact directed to seek the whereabouts. That report has come, my lords. He is not able to be traced. Even the inhabitants of the locality were unable to say about his whereabouts.
What to do? What was the age in the time of trial? 63 years.
63.
In the year 1992.
1992.
What is the now? How many years?
24 हो गए.
बताओ. 92 रे जदी 63 थिला वर्तमान केते हितियो?
63.
काउंट करो ना. हां.
More than 90 years, matters.
No, more than 93 plus 92 again 32 years.
Yes.
33 years. 33 plus 63. How much?
96 months.
96.
96.
96 years they could once you. You are not able to locate.
No, matters. Last inquiry was done on 2/12/23. In fact, spies were also been engaged to ascertain about his whereabouts.
The what is the address? Chandra Behra. Agent of Bosti Nagaon. Right. The IAC Boriguma police station. Huh? Boriguma na?
Yes, matters.
नहीं.
Boriguma, PS Boriguma matters, Koraput.
IIC PS Boriguma, And another address is given, two address. What are the address?
Agasthigaon, Chhatarpur, my lords.
Chhatarpur, Agasthigaon. Give me, who are the IIC? If you can't get the information, we will give direction. Who are the? Which IIC? Boriguma IIC and?
Boriguma and Chhatarpur IIC.
IIC Boriguma and IIC Chhatarpur is directed to submit a report regarding the status of the present petitioner, present appellant in the case. It is pointed out from record, Mr. Rijvi pointed out from record that in the year 1992, when the trial appeal was filed,
Yes.
the petitioner was
63 years.
By now, the appellant,
Appellant.
the appellant is was 63-year-old. By now, he has attained
96
about
years.
96-year-old. So therefore, the status of the petitioner is required to be verified. In view thereof, PS Boriguma and PS Chhatarpur is directed to supply a report. Place it on next week. And immediately, RIC is directed to intimate, inform the IIT Boriguma and Chhatarpur NCK report. Release the matter next Friday.
Government councils need to transmit the order.
A copy of the same order is maybe
आम्ही
supplied
मागितली.
to Mr. Ragada to intimate inform the concerned police station. This will be the same recorder. Free copy. Yes.
88.
1 week after.
Yes, madam.
88, appellant age is 50. Where about maybe
50 at the time,
50
90,
at the time of 92 years.
50, 50.
50.
Must be 80.
My lords, we have obtained the whereabouts. The last report came on 11/2/2021. He is very much alive. He was very much alive on 11/2/2021. He was unable to speak actually, but he was alive.
21.
In the year 2021, he was alive.
Right on. At the time of filing of the appeal, the petitioner was 50 years. Like this, the present appeal is pending since 1992. At the time of filing of the appeal, the petitioner was 50 years old. 50 years old?
My lord, it's not legible actually. It's not legible, my copy.
How have you said 50 years?
Judgment 50 years.
In the judgment, my lords, he was 50 years. Yes. On 26th March 92,
52.
he was 50 years.
50 years old.
Yes.
50 years old.
92.
Mr. Rijvi, learned counsel for the petitioner submits that a report was sought from the concerned police station.
SP Vigilance,
SP
Sambalpur.
Vigilance. Report was sought from SP Vigilance. Avoid status report dated
11/2/2021.
11/2/2021. It was reported that the petitioner was alive, but he was not able to speak.
Yes.
Able to speak. Then counsel for the petitioner submits that she would be getting instruction regarding the present status. The vigilance SP, na?
SP Vigilance, Sambalpur, my lords.
SP Vigilance Sambalpur is also directed to obtain first instruction and place it on record, release it on Friday.
My lords, I am sorry, he was not able. I have submitted it. He was not able to speak, but he had a fracture in his right leg. He has only a fracture in his right leg.
Not able to speak.
Yes.
And press status report Friday. Free copy to Mr.
My lords, this Friday.
Next Friday.
Next Friday, my lords.
No, Monday, Tuesday, Friday.
Sir, Friday रहने दीजिए. नहीं आ पाएगा इतने
Next
जल्दी.
Friday. ठीक है.
89 also. 89 also. Noting is that. Noting is that wherever.
What was his 89 at the time of filing? 18. You want a 45, you want a 50, you want a 56. तीन report अच्छी
85, my lords. 85, we are not having a copy, my lords.
first appellant was 45 years. Second appellant was 50 and third was 56 in the year 1992. Status Magam. Vigilance, which vigilance? SP vigilance, Koraput, Koraput, Cutter.
89 members.
Where from we will get the report?
He is from Koraput, my lords.
Koraput and Cutter.
My lords, let me see the judgment. There the vigilance just must have been mentioned. Sambalpur, my lord. SP vigilance, Sambalpur.
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 The SP vigilance Sambalpur is directed to place a report regarding the present status of the appellant. The appellant number 1 was 45 years, whereas appellant number 2 and 3 are 50 and 56 years respectively in the year 1992 when the appeal was filed.
As the appellants belong to Koraput, your lordship may direct the SP Koraput vigilance Koraput.
And SP vigilance Koraput shall file a report, whereas appellant number 3 is concerned, SP vigilance Cuttack should obtain the instruction, place it under court. The copy of the order, free copy of the order is to be supplied to Mr. HB to communicate the same to him. And registry is also directed to communicate. Yes. So Friday law. Yes.
90.
Please, your lordship. 1993, 38 years. He is alive. Alive.
3 years back he was. Please, your lordship.
Where all born?
He was the senior clerk in the sub-treasury Burla, my lords.
Mr. Rizvi, ready?
Yes, my lords.
And it is alleged that he demanded a bribe of 1400, which was subsequently pared down to 900 rupees for getting the pension papers of the informant's father prepared and finalized. A trap was laid, and in the trap, my lords, he was detected with the bribe money in his person. And his plea, defense plea was that the bribe money was not bribe money, but it was money which was a loan which had been taken by the informant's father, and the informant was repaying that. The charge is at page 22. He has been charged for having committed an offence under 5(1)(d), punishable under 5(2) of the PC Act 1947 and 161 IPC, my lords. There are 5 witnesses, my lords, examined by the prosecution, of whom PW1 is the informant. The evidence of PW1 is at page 28.
Paper there. 28 of what you are referring?
28 of the
Page
paper book.
28 of the paper.
Paper book, my lords.
There, paper book there. You are giving. Yes. 28, right. Charge was, you said charge is 22.
Yes, ma'am.
Is
22.
Is 20? 28.
28 is the evidence of PW1, the informant, decoy.
Yes.
His evidence is like this. My father, late Nandaram Banchor, was serving as a sweeper in Burla Medical College Hospital about 6 years back, and he, having worked as such, retired from service. After retirement of my deceased father, I had been to Bhubaneswar on several occasions for getting his pension and gratuity, and for that purpose I had been to the office of the Director of Treasuries and Inspection Bhubaneswar. After getting the pension papers prepared and passed in the office of the Director of Treasuries and Inspection Bhubaneswar, I came to Burla Sub-Treasury for working out the same. I was introduced to the accused, namely Dayalal Bag, serving as senior clerk during the relevant time. When I requested the accused to pass the pension papers for the purpose of payment and of pension and gratuity, he told me that the matter cannot be finalized so soon and necessary calculation was required to be made for the purpose. Accused, having calculated the pension and gratuity, gave me to understand that my deceased father was to be paid an amount of 14,585 towards the same. Accused demanded illegal gratification of 1,400 for getting the work done. I expressed my inability to pay the amount as I was earning my livelihood by pulling rickshaw. So the allegation is that I demanded illegal gratification in order to calculate the pension and gratuity and to pass the pension papers. And I have calculated the pension and gratuity, but for passing the papers, I asked for a bribe. Now, my lords, your lordship, that paragraph 2 I am placing, he says, accused demanded illegal gratification of 1,400 for getting the work done. I expressed my inability to pay the amount as I was earning my livelihood by pulling a rickshaw. Relating to the illegal gratification made by accused, to show me favor for getting pension and gratuity of my father payable, I disclosed the same to my friends and relatives, including one Tappan Kumar Swami. This is PW2. The overhearing witness. Then myself and Tappan approached accused for getting our work done. Though myself and my friend Tappan went and requested the accused for payment of the dues, your lordship may mark this. He insisted for payment of 10% of the total money outstanding against my father. At this, I agreed to pay the bribe money to the accused. Accused directed me to come on a Wednesday on a specific day, which I do not remember, with the bribe money of 1,400. Whereupon I agreed to pay only a sum of rupees 900, to which he accused agreed. This again, your lordship may mark that he was directed to come on a Wednesday on a specific day, which the witness doesn't remember. And he was asked to come with 1,400 and he agreed to pay 900 and accused agreed to that. Accused told that after I pay the bribe money of 900 to him, he would return the pension book of my father. So first, my lords, the demand is for passing of the pension papers. Demand was 10%, which was pared down to 900 rupees. And he was asked to come on a Wednesday, on a day which the informant doesn't remember, and was told that the pension book of his father would be returned after 900 rupees was paid. Then he says that he came to the SP's office, lost FIR, trap was laid, and the trap was successful. Now, my lords, your lordship may look at page 31 of the paper.
Cross.
No, it's chief.
Yes.
I don't want to place those portions because they are all. Paragraph 4, my lords.
Yes.
He says,
There
is a petrol pump in front of the office of the accused. When the jeep reached the petrol pump, vigilance officer got down, including ourselves. They took their position near the spot, whereas myself and Tappan proceeded to the office of the accused. Tappan was directed to give a signal by brushing hands over his hair, overhear the conversation between myself and the accused, and to witness the payment of the bribe money. Tappan stayed in the veranda in front of the office of the accused, and I went near the accused. Accused was busy with other staff in his work, so I called him outside. Next page he says, accordingly, accused came to the veranda of the office, questioned me if I had brought the bribe money, to which I answered in affirmative. Then I put out the money from my backside pant pocket, handed over the same to the accused, who counted the money, put the same in his left side chest pocket. Now, this, my lords, is said to be the demand and acceptance has been proved. Now, my lords, so the demand and acceptance is stated to be proved for passing of the pension papers and for handing over the pension book after receipt of 900. Now, he says thereafter, accused counted the money and put the same in his left side chest pocket. No sooner accused accepted the bribe money and put it inside his pocket, accompanying witness, namely Tappan, gave the signal. Accused on receipt of money went inside the office room, and that the vigilance staff on getting the signal rushed to the spot, entered inside the office room where accused was sitting. Vigilance staff challenged the accused, disclosed their identity, and said that he had accepted the bribe. Now, your lordship may see, in this narration which he is giving, he doesn't say that the accused handed over my father's pension book to me. He doesn't say that. Then he says, when the vigilance staff challenged the accused,
before he could give the pension paper, the vigilance people interviewing.
That is why I am placing this. Then he says, accused became pale, hand wash of accused was taken, resulting in turning of the solution to pink color. Accused was asked to put out the bribe money and gave the same to the vigilance staff. The note numbers of the tented money were compared with the numbers noted previously. Shirt pocket wherein the money was kept turned to pink. Solution and shirt were seized by the vigilance. Now the next sentence is important. I gave the pension book of my father to the vigilance staff, which was seized and kept in my jimma. My submission is this. What he said at the initial stage is that accused told that after I pay the bribe money of 900 to him, he would return the pension book of my father. This is what he has stated at page 20.
But while paying the money, he has not returned. That's what
he has not said that the accused has returned.
How come it is seized?
But he says that he has given the pension book of his father to the vigilance staff who seized it. So the pension book, my lords,
was with him only.
All along with him. This is evident, my lords, again from cross-examination. In cross-examination, my lords, your lordship may look at paragraph 6 at page 34. He is speaking about the
you complete the sentence. That is very important.
Yes.
The pension book
originally is lost because when my father died and was cremated, the same was thrown inside the fire. So the pension book which was with him, he gave to the vigilance people. They seized it, gave it to him in Jimma, and he has thrown that pension book which was in his Jimma when his father died into the funeral fire. And he says that he has executed the Jimanama, that is Exhibit 2. His father is dead since 2 years back. Now, my lords, so far as the bribe money is concerned, my lords, his answer in the cross-examination is important. And that shows that on the date the strap was laid, there was no work pending for the accused to demand the bribe. My lords, may kindly look at page 34 of the paper book, paragraph 6.
6. So, the amount
Which I produced before the vigilance staff on the day of laying down the trap, the same was paid out of the amount which we withdrew from the bank towards the pension and gratuity. Now, pension book is with him. He produces it before the vigilance people. And now he says that the money which he has brought and produced before the vigilance to be paid to me, that is from out of the money which he and his father have withdrawn from the bank. So on the date of the trap being laid, there was no work pending. And that is why the gentleman says in the very beginning that accused asked me to come on a Wednesday on the date which I do not remember. Because by the time he has gone and lost the FIR, accused has already done his work, passed the pensions for payment, my lords, and he has also taken the pension book from the accused, taken his father to the bank, withdrawn that money from the bank, and out of that withdrawn money, he brings 900 rupees, which he gives to the vigilance trap laying officer, which is treated with phenolphthalein and is given to him for the purpose of laying of the trap.
No, what is wrong in it?
Let's see.
If he has done the work, thereafter the demand which he has...
Thereafter, what is the question of a demand, Miller?
Now, you are not doubting insofar as the trap is concerned. What you are saying is, on the day when the trap was
What
taken,
I am
by that time the work was already done.
Yes, what I am saying is...
But he promised to pay, he paid.
There is no, the promise to pay, the promise to pay.
He said that 1400 was demanded.
I am with chief
and scaled down to 900.
My lord, I am reading from the chief, I am reading, again I am reading it once again. He has said at page 29, my lords may look at,
yes,
6 lines from the bottom.
Right.
Accused told that after I pay the bribe money of 900 to him, he would return the pension book of my father.
You say there was no occasion for returning without paying.
I say, my lords, that since pension book is already there with him, he has withdrawn the money, there is no occasion for demanding of a bribe. And my defense plea is believable.
Yes.
That a loan was taken which was being repaid.
You had taken loan from me.
He had taken a loan from me. That is my plea in the accused statement, and I have cited a defense witness also.
If he has taken the loan, why have you paid?
I have not paid. This money which was being used for the trap, my lords, that is the repayment money which he was to repay me for the loan which had been taken earlier.
It was handed over by you to him.
Which?
Money is handed over by you to him. It's not reverse.
No, my lords. The trap money is handed over by PW1 to me.
Yes. No, PW1 to you.
PW1 hands over to me.
Right.
And he says that this is a bribe. Bribe for returning the pension book.
I understand.
But he says that he produced the pension book.
So what you want to say is your defense is fortified because of the cross-examination, what he says.
Yes.
On the day when the trap was, LA's trap was done.
Because
that time there was nothing to be.
Right, my lords.
So there was no occasion for you to pay.
Yes, there was no occasion for me to
demand.
demand.
Bribe money, obviously it is for some other purpose.
Yes.
That's what you are
That's what I intend to say.
The 900 you might have paid, but it is not meant for bribe. It was for loan or whatever.
Yes.
Your defense is loan.
That is my defense.
But it is not, definitely it is not for bribe.
My lords.
That's
Now,
his case.
again, your lordship may see what he says. That page 34 I am placing. The amount which I produced before the vigilance staff on the day of laying down the trap, same amount was paid out of the amount which we withdrew from the bank towards pension and gratuity. I brought the connected pension papers pertaining to my father from the treasury, obtained the signature of my father, got the token from the bank, and then I withdrew the money myself. So he has the pension book with him. It has been passed by me earlier. He has withdrawn the money from the bank, my lords. And therefore, my lords, my submission is that the question of demand for the purpose of passing the pension and returning the pension book thereafter on receipt of the bribe, that is not made out. Then suggestion, my lords, may look at para 7.
Yes.
Tappan, who accompanied me from the very beginning of the episode, is my friend. It is not a fact that accused had asked for a loan of 900 from my deceased father, which he promised to pay after he receives the pension. It is not a fact that my father instructed me to pay 900 rupees to the accused after the pension amount is drawn, for which there was difference of opinion between myself and my father. It's not a fact that with an apprehension that the accused may not repay the amount, I, along with my friend Tappan, hatched a plot and made a false complaint against the accused, resulting in the trap. I did not disclose about the fact of demand of 1400 as bribe by the accused at the first instance, and ultimately he agreed to receive rupees 900 either before the sub-treasury officer or before any office staff of the treasury. It's not a fact that in order to put the accused into unnecessary trouble and harassment, I have falsely reported against the accused before the vigilance staff and other members of the raiding party. Now, my lords,
You read 9 also.
Yes. On the day of detection, when I went inside the office room, where accused was sitting and working, he questioned me, "Paisa ani acho ki?" I said, "Paisa ani achi." This has to be juxtaposed, my lords, with what he has stated at page 32. Accused came to the veranda of the office and questioned me if I had brought the bribe money, to which I answered in the affirmative. Cross recouchi that the query was made inside the office room. So it would not have been heard also by the overhearing witness.
Right.
None of the office staff where the accused was working have heard such conversation as stated above between myself and the accused just before the payment of the bribe money, except Tappan, who was at a distance of about 3 to 4 feet from us at this spot. Tappan all along says that he was at the veranda villas.
PW2 is Tappan.
Yes. Sir. PW2 also, your lordship may see what he has said. Page 36. Para 2, my lords. On 24/6/88, complainant PW1 told me that accused was demanding 1400 rupees as bribe to show favor for passing the pension bill of his father. And though he was expressing his inability to pay such a huge amount, yet accused is not paying any heed to the same. Complainant PW1 requested me to accompany accused for getting a settlement in that matter. Accordingly, on the following day in the morning, I accompanied complainant PW1 to the accused. We met the accused. I requested the accused to exonerate him from paying such a huge amount, as PW1 was a poor man. I made repeated requests, and at long last accused agreed to take 900 rupees as a bribe from PW1 in order to show favor to him.
So demand is there.
Yes.
The demand is proved.
But accused further said that after PW1 would pay the bribe money, he would give the pension papers. Pension papers.
But the whole case is demand is proved, acceptance is
Proved,
but
yes.
the acceptance is in lieu of the loan. That's
Yes.
what the loan.
By the time the trap is laid, the work is already done.
If his story is to be believed, defense story is to be believed, the prosecution, even if it is demanded or accepted, the prosecution story has to be discarded. Because he is not questioning the demand, he is not questioning the acceptance. What he says that I have, but it was
in the form of loan. This is what he wants to establish, my lords.
He wants to establish that, and from the PW1, it apparently gives a hint that it was for the purpose of loan. Because on that day, when the money was paid, it seems the pension paper and everything was in possession for which the bribe was supposed to have been given.
Right.
How it has come on his hand.
And he himself says that he obtained the bribe money from the bank out of the pension.
That is what. Yes.
If he has finished.
Anything else?
Now, my lords may look at same PW2.
You want to substantiate the same
Yes,
thing?
yes. My lords may look at PW2 again. What is this? On 28/88, vigilance raiding party came to Hirakud rest shed for laying down a trap to catch hold of the accused. I accompanied PW1 to the rest shed on that day. Magistrate and vigilance officers were present. Complainant PW1 was introduced to all in our presence, who narrated about the demand of bribe money by the accused to the tune of ₹900. Vigilance officers directed to be an accompanying witness to go to the spot at the time of detection, give signal by brushing my hands over the hairs, and to over the conversation, it will be over here, the conversation between PW1 and the accused at the time of payment of the bribe money. I was searched, but nothing was recovered from my possession. PW1 produced 50 rupee GC currency notes, 18 in number before the vigilance staff. Magistrate noted down the numbers of the notes in a paper and put the same in his pocket. PW1 was directed to give the money to the accused only on demand at the spot. Demonstration of the solution coming in contact with phenolphthalein powder was made by a vigilance officer before us. The color turned pink when the fingers were dipped coming in contact with the powder. Powder was smeared on the tainted money, which was put inside the pant pocket of PW1. A preparation report was made, Exhibit 3. 3/1 is my signature. After the preparation was over, we all went in a jeep to the spot. At a little distance from the spot near a petrol pump, raiding party took their position, directing me and PW1 to proceed ahead, whereupon we went.
Let us see 313.
No, এটা খালি para 3 রে চারটা লাইন দেখি। I stayed just beyond the veranda of the office room. PW1 went inside the office room where the accused was working. Immediately thereafter, both PW1 and the accused came to the veranda of the office room. Accused questioned PW1 if he had brought the money, to which he answered in affirmative.
Yes.
Now, this is juxtaposed with what PW1 says at paragraph 9 in cross.
Paragraph 3, just see.
Yes.
Paragraph 3, page 38.
3 paragraph. 3
Last
रे
line.
देखो
No, this is going against you. The vigilance staff returned the pension papers
to PW1.
PW1, who executed Jimanama.
Yes.
To that effect.
Yes.
It doesn't go against me because
he has paid Jimanama.
PW1 himself says that I handed over it to PW. To
And
the vigilance.
he received it and handed over.
Yes. Vigilance people received it and handed over.
No. Vigilance staff returned the pension. After the moment you paid the bribe, the accused might have said that return the paper.
Return the papers.
He returned the paper.
Where does the question of might have come? Where does might have come in a criminal trial?
No, that's right, but this is
my submission is this.
Affirmative
Yes,
sentence.
my submission is this. The evidence of PW1 is what? What is the evidence of PW1, my lords?
No, PW1 says that I have given it. It was there with me. How it has come to his possession is that after 900 rupees is paid, the vigilance people have given him the paper. That is how he gave it back.
Yes. Lords, my submission is this. According to PW1, your lords, you may just bear with me.
Yes.
According to PW1, my lords, that after 900 rupees was paid, the pension book was to be handed over by me to PW1. PW1 in his evidence has stated that after the bribe money was handed over, he produced the pension book to the vigilance staff, page 32. That your lordship may see, page 32. 1, 2, 3, 6 lines from the bottom.
Hmm.
I gave the pension book of my father to the vigilance staff,
Right.
which was seized and kept in my jimma.
Jimma.
Before that, he has not stated that accused has handed over the pension book to me after receiving.
That PW2 says.
PW2 also doesn't say that. What PW2 says is that this
Vigilance staff returned the pension
Yes.
paper to PW1.
Again.
Who executed Jimana?
Yes, that corroborates PW1's version that after the pension book was given to the vigilance staff, they seized and gave it in his jimma.
Let us see what is your defense.
Yes.
13, let us see.
Yes, your lordship may see. 13.
Page 23.
Hmm?
Page 23, it starts the statements. Explanation has been given at page 27, question 20.
20.
Yes.
20.
What have you got to say?
Have you got to say? Yes.
ସେ ଟଙ୍କା ମୁଁ ନନ୍ଦରାମ ବାଞ୍ଛରକୁ ଆଗରୁ ଧାର ମାଗିଥିଲି। ସେ ମଲା ପୂର୍ବରୁ ତାର ପୁଅ ରାମସାଇ ବଂଶର ହାତରେ ସେ ଟଙ୍କା ପଠାଇ ଦେଇଥିଲେ। ଧାର ମାଗିବାଟା ଅନ୍ୟମାନେ ଦେଖିଥିଲେ ଓ ଶୁଣିଥିଲେ। Will you adduce defense? Answer ହେଲା ହଁ। Defense
ଧାର ମାଗିବାଟା ଅନ୍ୟମାନେ ଦେଖିଥିଲେ ଆଉ ଶୁଣିଥିଲେ।
ଆଜ୍ଞା।
Have you laid evidence?
Yes.
Evidence.
Page 50 of the paper book.
Huh?
Page 50 of the paper book.
Yes. DW.
Witness number 2 for the defense.
Yes.
Santosh Kumar Panigrahi. I am a peon working in Sub-Treasury Office, Burla. Since 1981, I have been working as such till today. I know the accused in dock. Once in the year 1988, he was trapped by vigilance police. On 28/6/88, such trap was laid against him. I know Nandaram Banchor and his son Ramsai. On 27/6/88, Nandaram Banchor, along with his son Ramsai Banchor, had come to Sub-Treasury Burla for getting his pension dues cleared up. The accused has already prepared his pension papers, got those ready for payment of bill. I took all the papers of Nandaram for his pension to Sub-Treasury officer. Sub-Treasury officer wanted to see Nandaram. I took Nandaram before the Sub-Treasury officer Burla. Sub-Treasury officer made enquiry from Nandaram and handed over his pension book. I gave the pension paper to the concerned clerk for issuing a token to Nandaram. A token was given to Nandaram. I took his pension papers to the bank with the advice. Bank is 2 to 3 furlongs away from Sub-Treasury office, Burla. Accused had nothing to do with the pension papers of Nandaram on 27/6 and 28/6, as matter was already finalized on 27/6/88.
Where does he say that the loan was given? Nothing is said. Nothing is regarding loan. That in my presence it was given or nothing is said. What is the use of this defense evidence?
Lords.
In the light of the stand you have taken very specific stand saying that when you gave it, ଦେଖିଥିଲେ ଶୁଣିଥିଲେ.
Aye.
You have not laid any evidence.
ତାପରେ ଦେଖନ୍ତୁ PW1 ଦେଖନ୍ତୁ ମହାଦେବ ପଣ୍ଡା DW1 page 48.
48.
Since 79, I have been residing at Burla. My wife is serving as a staff nurse in VSS Medical College, Burla. I know the accused in the dock. Accused belongs to the hamlet where the house of my father-in-law is situated. I know Nandaram, father of complainant. Sri Banchor is a sweeper posted at VSS Medical College Hospital, Burla, where my wife is serving. About the 3rd week of June 88, accused in dock approached me to arrange rupees 1500 for him. I paid rupees 500 available with me then.
And 1000 is paid by the accused.
I asked Nandaram Banchor to pay a loan of 1000. As
1500 was the loan amount, where 500 he has paid and 1000 your father paid. I know that.
Nandaram said that he had no money with him, promised to pay a loan of 1000 to the accused on receipt of his pension dues I stood as surety for the loan. Cross-examination ଦେଖନ୍ତୁ. I do not know when Nandaram retired from government service. I cannot say the strength of sweeper serving at VSS Medical College. I did not keep any account of the loan amounting to 500 I had advanced. Nandalal had his residence close to ours. At 5 p.m. we had been to his residence for the balance loan. I cannot give its date. When accused was trapped, he reported me about the loan taken from Nandaram. I could recollect the month when we had been to Nandaram. I was not present on the date when the accused was entrapped. He reported me about the loan taken from Nandaram 25 to 30 days after we had been to the house of Nandaram. Then, this is with regard to the trap millers. That by the time the trap was held, the work was over.
Yes.
Then there is with regard to sanction millers. Your Lordship may see the evidence of PW3 at page 41.
We'll hear tomorrow.
Yes, sir.
Continue.
2 o'clock.
2 o'clock. And you get ready.
Yes, ma'am.
No, very good. Got it, got it. Good, too much.